Specially assigned matters today.
বলেছিলাম তো। It is our fault. What to do? Friday before.
But anyway, Malad, today we'll see, Malad, if
What is that?
court is happening, Malad.
Court is happening. Malad, even Malad, there's no difficulty. Malad, Mr. Mukherjee is also here. Malad, my matters, Malad, before that. So, Malad, I am in both. Malad wants to take up also, Malad, for some time. Malad, I don't have any difficulty, Malad, in that happens.
We will go by the sequentially. We'll go.
So Friday morning, Malad, I'll have some Malad difficulty. That's the only difficulty, Malad.
Let us see. It may reach today also.
Yes.
In the
The
ordinary.
only thing is, I had indicated that, my lord, afternoons of Monday and Tuesday, I'm in difficulty, which is why your lordship had placed it, my lord. Had
If all sides are here, we can take it up also.
I think that's the resolution also, my lord, that no adverse order in the absence of any party. And these are hearing matters, my lord. I don't think any.
Very well. Immediately after new application.
Very well.
Malad,
My lord, my lord, my learned friend says to my lord, split the time, my lord, between his continuing.
I also, Malad, have a continuing.
Start and then we'll see.
Yes.
Yes. First mobile, then gas.
Yes.
Correct.
CBM, Malad, can't go away, Malad.
All right.
I say, my lords, kindly to mention item number 51 of my lord's list, my lord. My lord, this is the Juice Gully matters regarding ascertaining the mean profit, my lord. My lord, on last week, my lord, the matter was called once by my lord. The list has collapsed. We could not reach the court, my lord. My lord, there is some urgency in this matter.
Sorry. We have called it. You were not there. For whatever reason you were not there, we can't upgrade it. It is number one appeal from orders.
My lord,
Number one
my
appeal
lord,
from
my
orders.
lord.
Next.
This is an appeal, my lord, which we have preferred, the non-commercial matter from, my lord, an order passed in a proceeding under section 643 of the Companies Act, executing an order sanctioning a scheme of arrangement. But we had taken a maintainability point, whatever it is, my lord, the learned court directed of the no due certificate. We have preferred an appeal. But I was only praying, my lord, if it can come up after 18th. I am in some personal difficulty, my lord. I will,
Yes. Your appeal, you do it whenever you want to.
I have only, but because, my lord, issuing a contempt proceeding before the Lord.
You can't have both, Mr. Sen. So will
But
it
if
come
a
up?
prayer for adjournment is made, your lord.
Yes, certainly.
May I be permitted to mention to application for injunction in connection with the first appeal of commercial appeal, my lord?
Lordship, may I have your lordship kindly to mention a matter? On Wednesday, we had mentioned before your lordship for leave to file without certified copy, your lordship. I just received the instruction. We have already filed our appeal. I've just received instruction from client that on Saturday they had it's a Section 9 order passed by the Honorable City Civil Court. Now, with regards to a loan taken on a Prius car. Now on Saturday they had again come. The representatives of the respondents.
What do you want?
Your lordship, if some precedents can be afforded tomorrow for tomorrow's list, your lordship. It's an appellate side matter, your lordship.
Commercial?
Non-commercial, your lordship.
We'll see. It is in the list already.
No, your lordship. It is due to appear tomorrow, your lordship. Some precedents.
It'll be taken up.
Some precedents.
Why are you? When it's called on, mostly you are not there. Chalo, dakho to.
My lord, may I have my lord's kind leave to mention one matter? My lord, this is an appellate side non-commercial, my lord, commercial, my lord, side matter. My lord, here, my lord, I have e-filed my appeal, my lord, and the injunction application on the 4th of September. The impugned order is, my lord, of 1st of September. My lord, my lord, it's an appellate side matter. My lord, there is urgency in the matter. My lord, my ad interim prayer for injunction has been refused. My lord, that is the reason why we have come up, my lord, for appeal, my lord, in appeal. my lord, if my lord kindly
এবার এই
takes up the matter.
টাইমগুলো নষ্ট লিস্টে ফাইল করেছি লিস্টে আসবে মামলা শোনা হবে নেক্সট
Very well, my lord. Obliged.
Item number 1.
I appear for the respondent, my lord.
অ্যাপেলেন্ট নেই পাস ওভার
Item number 2.
Granted leave, my lord, to file supplementary affidavit.
সরি
I was granted leave on the last occasion to file supplementary affidavit
ফাইল
to
ইট
bring on record the plaint, my lord.
ফাইল ইট
File.
দে আর নট হিয়ার সো
So my lord will,
what shall we adjourn it for the day or
my lord will do that. My lord will record that I would file.
supplementary affidavit filed by the appellants be kept with the records. Paragraph, the respondent is not represented. Paragraph lists the matter once again on Friday, date the other Friday, Mr. Mukherjee.
My lord.
Item number 3.
My lord, it is my appeal, my lord. My lord, it's my appeal, my lord. I'm sorry, my lord. The virtual mode, my lord. I mean, it's my appeal, my lord. My lord, so, my lord, for the appellant, my lord. Now, my lord, the respondents are not here, and also, my lord, my stay application, my lord. My lord, direction for paperwork, my lord, for the application, my lord, is not there in the list, my lord. Because only the memo is there. The memo of appeal is there.
What do you want, Mr. Malik?
My lord, may it be, my lord, I'll be praying for a deduction for paperwork, my lord, because, my lord, there is no scope of stay of any order, my lord.
Have you filed any application?
No, my lord, it will be filed, my lord. It will be filed, my lord. It has not been filed, it will be filed, my lord.
But if you say there is no scope for passing interim order, why
Yes, my
file
lord,
an
because, my lord,
application?
it is an application under Order 12, Rule 6, which has been dismissed, my lord. Hence, my lord, there is no scope of filing an.
Then why are you filing an application? We have not followed.
My lord, I believe, my lord, I have been said, my lord, that an application is required for a direction to be passed for regarding paperwork, my lord.
এরকম কোনো নিয়ম আছে নাকি?
My lord, I have been told, my lord. I don't know, my lord.
The application you please, we'll make it not today. You please find out.
Yes, my lord.
And we don't think what you have been told is correct.
But I'll
That we
come
can't
back
give
tomorrow, my lord.
direction for filing of paper book unless an application is filed. Doesn't sound quite very logical. Anyway, not today.
Grateful, my lord. Come back tomorrow.
কোথায় ফোনটা? হ্যাঁ ও পাসওয়ার্ড আছে দেখো তাহলে পাসওয়ার্ড
Customer matter. Item number 1.
না is there a resolution? Are you not to pass adverse order? Then not today.
Grateful.
Speak from order. Item number 7, 8, and 9.
Compliance certificate for the
Copyright actor, Millard, this is a interesting question. Millard of law, Millard, which is involved in this case. And it's consequent, Millard, to the amendments to the Copyright Act, which Millard were made in Millard 2012. Now, Millard, the principal issue, if your lordships kindly take the impugned order once, Millard, in the memorandum of appeal.
All three appeals against the same order?
Yes, yes, Millard, there is. Millard, I'll just show one paragraph from the order, Millard, before I go into, Millard, the facts, and then, Millard, come to the law. Paginated the order also. That is the Millard, paragraph 5 of the order, Millard.
Paragraph 5.
Yes. Millard, it's internal page 3. And Millard, if your lordships have a running page, it will be page 32. Millard, kindly see, Millard, 4 lines here, paragraph 5. The crux of the issue in these proceedings is whether Vodafone is required to obtain a separate license from IPRS and pay royalty before commercially exploiting the musical and literary works of its members as part of the sound recording. Millard, this is, Millard, how, Millard, the learned judge, Millard, identified, Millard, the crux of the issue. Millard, I just want to add, Millard, one thing, Millard, which has led to, Millard, the issue being framed like this. Millard, there is, Millard, no recognition, Millard, of the fact, Millard, when framing this issue, that a copyright in a sound recording is an independent and separate copyright, Millard, compared to, Millard, when, Millard, taken, Millard, with, Millard, copyright in musical works or copyright, Millard, in literary works. But, Millard, I'll address that issue, Millard, in the course of, Millard, arguments. Now, Millard, 3, Millard, brief facts, Millard, I must indicate before, Millard, I show your lordships, Millard, the relevant provisions of the Act, the amendments, and, Millard, what our reading, Millard, of, Millard, the Act is. Millard, Saregama, your lordships aware, Millard used to, Millard, at one point of time, own the copyright. Millard, this was, Millard, HMV, Millard, in its previous avatar, Millard, which, Millard, owned, Millard, the copyright, Millard, in the soundtrack of, Millard, various films, which naturally included, Millard, all the film songs. In effect, Millard, it's been judicially recognized also, the formats of the agreements, Millard, which were entered into then, were, Millard, to, Millard, manufacture gramophone records. Millard, records was the sound recording came in later. Millard, in the Copyright Act, Millard, it was earlier, Millard, gramophone records. The definition of records was there and copyright, Millard, in, Millard, records. Now, Millard, what used to happen, Millard, was, Millard, a producer, Millard, would, Millard, produce a film. Millard, under the Copyright Act, Millard, he by virtue of, Millard, being the producer, became, Millard, the owner of, Millard, every work, Millard, which formed part of that film, including, Millard, the owner of the copyright, Millard, of the film. Millard, the music companies, Millard, would also have, Millard, would, Millard, be engaged, Millard, to, Millard, produce, Millard, the songs. Now, Millard, as producer, Millard, they would engage, Millard, musicians and, Millard, performers. And, Millard, they would become, Millard, the owner of the copyright, Millard, of, Millard, the lyrics by virtue of being producer. There's no assignment here. And, Millard, of, Millard, the musical works and, Millard, the literary works. Literary works are the lyrics. Musical works, Millard, is, Millard, the tune, Millard, which is, Millard, given. Now, Millard, the celebrated judgment, my lord, of the Supreme Court, my lord, against, my lord, a copyright society, is that reported in 77 Supreme Court. I'll come to that. Then, my lord, there were certain amendments, my lord, made to the Copyright Act, my lord, recognizing performers' rights. So, my lord, if one gets on and performs, my lord, and that, my lord, is recorded, then, my lord, he has a right, my lord, to, my lord, the copyright in that. So, performing rights, my lord, were, my lord, recognized. Then broadcasting corporations, my lord, were recognized. And then comes, my lord, the change in the law in 2012. My lord, it is the contention, my lord, of, my lord, the, my lord, IPRS, my lord, the Copyright Society.
IPRS is represented by.
Yes. My lord, is, my lord, in short, that, my lord, the copyright in all literary and musical works, my lord, is, my lord, of, my lord, the authors of such works, my lord, which the authors have, my lord, are, my lord, owned, my lord, by, my lord, the Copyright Society, or they are, my lord, they've been engaged, my lord, to collect, my lord, whatever royalty, my lord, is payable, my lord, in respect of exploitation of these works. Music companies only own the sound recording. So, my lord, according to them, the 2012 Act, my lord, if a sound recording has, my lord, any music or lyrical works or lyrics, my lord, for which there are separate copyrights, then, my lord, their consent has to be taken for, my lord, any broadcast, my lord, of that sound recording. My lord, this in short, my lord, is their case, because they say musical and literary works, my lord, incorporated in the sound recording, my lord, a separate license has to be taken for the purpose of, my lord, even broadcasting, or, my lord, without, my lord, using the musical work, my lord, in any fashion, but, my lord, by simply broadcasting a sound recording, this is required. Now, my lord, before all this came to the fore, my lord, we had filed a suit, my lord, against, my lord, Saregama. There were disputes, my lord, with regard to, my lord, them, my lord, giving us, my lord, a license. Now, why Vodafone? My lord, we have, when, my lord, in mobile telephony, my lord, we provide some value-added services. Prime example, caller ringtone. My lord, where, my lord, music, my lord, is played. Now, we've had, my lord, sound recordings, my lord, licenses, non-exclusive licenses provided by Saregama under the umbrella of a master agreement. There were disputes, my lord, as to, and, my lord, under the master agreement, from time to time, my lord, licenses were granted. My lord, there came a situation where there were disputes with regard to, my lord, the, my lord, terms and conditions, my lord, of, my lord, the next renewal, or, my lord, how, my lord, the license agreement would be. And that was, my lord, primarily because of the amendments introduced, my lord, in the 2012, my lord, Copyright Act in 2012. There were certain disputes. So, my lord, we, my lord, filed a suit, my lord, seeking, my lord, a declaration, my lord, with regard to, my lord, the, my lord, what should be the terms in effect, and, my lord, that, my lord, no steps could be taken against us, my lord, for infringement. Saregama was a party. IPRS, my lord, was also a party. Now, my lord, in that suit, certain interim orders were passed, which also required us, my lord, to deposit as an ad interim measure, my lord, certain monies. Now, my lord, Saregama, my lord, also filed a suit. My lord, they said, my lord, that we should be restrained from in any way, my lord, broadcasting, my lord, the caller ringback tunes, saying, my lord, we didn't have a license from them. And therefore, my lord, they filed, my lord, a suit. This was the second suit. And then came, my lord, the third suit of, my lord, the Copyright Society, which was, my lord, to the effect that, my lord, and my lord, this did not concern, my lord, musical works or, my lord, literary works or sound recordings, which were, my lord, copyright of which had vested in Saregama. My lord, this concerned other music companies and, my lord, my clients, Vodafone, saying that, my lord, for any, my lord, musical works, any sound recordings, my lord, that we, my lord, broadcast by, my lord, providing value-added services. my lord, communicate to the public, my lord, we would, my lord, have to pay, my lord, royalty under a license to be obtained, my lord, from IPRS for, my lord, the musical works as well as the literary works. And my lord, our case is, my lord, once we have, my lord, a license agreement, my lord, with, my lord, Saregama for communication of the sound recording, we need no further license. My lord, this is, my lord, the, my lord, position in short. Today, my lord, as far as the second suit is concerned, my lord, whatever, my lord, was payable to Saregama, and, my lord, what was to be the agreement, my lord, have been entered into. In fact, Saregama had agreed, my lord, to withdraw the suit, and, my lord, had, my lord, applied for withdrawal, which was not allowed, but instead, my lord, in their application, my lord, IPRS, my lord, was, my lord, added as a party. In fact, we had initially also wanted, my lord, them to be added as a party. But, my lord, while that application was pending, there was a settlement. Saregama wanted to withdraw, was not, my lord, allowed to withdraw.
Saregama is before us today.
Should be, my lord. Now, my lord, this is, my lord, the factual position. Now, my lord, I've shown your lordships, my lord, the crux of the issue. My lord, why those amendments came in, my lord, now, my lord, what is important, my lord, is to see, my lord, the Copyright Act as it was, my lord, in 1977. My lord, when, my lord, we had, my lord, in fact, my lord, from 74, we had, my lord, 2 Calcutta High Court decisions and 1 Supreme Court decision, my lord, which, my lord, squarely, my lord, dealt with the position, my lord, of, my lord, a, my lord, composer, my lord, a position, my lord, of, my lord, a music composer, position of a lyricist, position of a producer, my lord, of, my lord, a cinematographic film, and, my lord, the owner of the copyright in the record. And, my lord, then, my lord, see how the law is developed and whether there is any change on this aspect of the matter as to whether, my lord, copyright in sound recording is a separate and independent copyright or not. So does it still continue to be so? My lord, is, my lord, really the subject matter of consideration here. Now, my lord, kindly take, my lord, the old Copyright Act. না আমার একটা বই ছিল হ্যাঁ ওরা এনেছে ওখান থেকেও দিয়েছ My lord, I've, my lord, got it photocopied from the AIR manual because, my lord, there have been a series of amendments. My lord, this was, my lord, the 1957 Act, and, my lord, gives the position, I think, as on 19, my lord, 65. Now, my lord, kindly take, my lord, section 2. Lordships have that, my lord. That's the interpretation section. And this is, my lord, the original 57 Act. Then I'll come to the amendments. My lord, section 2D, my lord, which is, my lord, relevant for, my lord. Kindly see, my lord, author. Author means, 1, in relation to a literary or dramatic work, the author of the work. Kindly note this, my lord. Then 2, in relation to a musical work, the composer. Then, my lord, kindly come to 5. In relation to a cinematograph film, the owner of the film at the time of its completion. And, my lord, 6, in relation to a record, the owner of the original plate from which the record is made at the time of making of the plate. This was, my lord, the original, my lord, definitions. Now, my lord, kindly come to my lord, literary work, which is, my lord, 2O. Literary work includes, my lord, it's an inclusive definition, includes tables and compilations. So, my lord, the yellow book, my lord, would also be a literary work. A telephone directory, my lord, would also be, my lord, a literary work. Then, my lord, kindly come to musical work. Musical work means any combination of melody and harmony, or either of them, printed, reduced to writing, or otherwise graphically produced or reproduced. Now, my lord, I pause here. My lord, this is Western influence. My lord, a lot of our musical work, my lord, would not fall, compositions may not fall into this at all. My lord, but my lord, several who play the piano, my lord, can identify with this. Combination of melody and harmony, or either of them, printed, reduced to writing, or otherwise graphically produced or reproduced. My lord, tabla bowls, my lord, could possibly, my lord, come into this with the matras and the beats. But, my lord, it's primarily Western influence and commented upon, my lord, by our courts, my lord, that when we look at a Beethoven, my lord, composition, this is exactly fitting into, my lord, this. Now, my lord, kindly come to, my lord, 2 Y, my lord. Now, W, my lord. Record means any disc, tape, perforated roll, or other device in which sounds are embodied so as to be capable of being reproduced therefrom, other than a soundtrack associated with a cinematograph. Now, my lord, kindly have a look at recording. My lord, 2X. Recording means the aggregate of sounds embodied in and capable of being reproduced by means of a record. Now, my lord, kindly come to 2Y. Work means any of the following works, namely, my lord, I am only concerning myself with literary, musical, my lord, cinematographic, film, and record. Work means any of the following works, namely a literary, dramatic, musical, or artistic work, a cinematograph film, a record. And, my lord, I must, for the sake of completeness, also show your lordships the definition of cinematograph film, which is 2F. Cinematograph film includes the soundtrack, if any, and cinematograph shall be construed as including any work produced by any process analogous to cinematography. So, my lord, a silent film, like, my lord, Charlie Chaplin's film, will not have a soundtrack. But, my lord, they can still be, my lord, copyright, my lord, in a cinematographic film, if, my lord, there is cinematography. My lord, Bengali film, which is not too old, Asha Jawar Majhe. My lord, I don't know if any of your lordships have seen that. My lord, is almost silent. Then, my lord, so, my lord, this is, my lord, how, my lord, these definitions. Now, kindly come to my lord, section 13. And my lord, this is very important. Lordships have had, my lord, the definition of works and, my lord, the definition of literary and musical works, definition, my lord, of, my lord, a record, and, my lord, what, my lord, is a cinematographic film. My lord. Now kindly have a look at section 13. Kindly mark the words subject to the provisions of this section. My lord, that's the first. And the other provisions of this act. So, my lord, not only the section, but other provisions of this act, these provisions are subject to it. Copyright shall subsist throughout India in the following classes of works. That is to say, kindly mark the words, original, literary, dramatic, musical and artistic works. We are really concerned here with literary and musical. Original, literary and musical works, cinematograph films and records. Now, my lord, kindly come to subsection, my lord, 3, 13.3. Copyright shall not subsist in any cinematograph film if a substantial part of the film is an infringement of the copyright in any other work. Then, my lord, in any record made in respect of a literary, dramatic or musical work. So, my lord, a copyright shall not subsist in any record made in respect of a literary, dramatic or musical work if in making the record, now kindly mark this, my lord, if in making the record, copyright in such work has been infringed. So, my lord, there is, my lord, a copyright in a musical work. When I'm, my lord, making the record, if I infringe, my lord, the copyright in the musical work, then, my lord, copyright in the record will not subsist. In the making of the record. Now, my lord, why, my lord, this is so? My lord, kindly come to, my lord, section 14. Or rather, my lord, I should also place subsection 4. The copyright in a cinematographic film or a record, kindly note this, my lord, shall not affect the separate copyright in any work in respect of which or a substantial part of which the film or, as the case may be, the record is made. So, my lord, there is, my lord, lyrics, which is literary work. My lord, there is, my lord, a composition, my lord, which is musical work. In respect of that, my lord, if a record is made, the copyright in those two works doesn't vanish, it still remains. This is, my lord, 13.4. Now, my lord, kindly come to, my lord, section 14. For the purposes of this act, copyright means, kindly mark this, the exclusive right. Now, the next words are also important. By virtue of and subject to the provisions of this act. A, in the case of a literary, dramatic or musical work, to do and authorize the doing of any of the following acts, namely, to reproduce the work in any material form, to publish the work, to perform the work, to produce, reproduce, perform or publish any translation of the work. Now, my lord, kindly note this. So, my lord, if somebody is the owner of a literary or musical work, Then, my lord, kindly see, to make any cinematographic film or record in respect of the work. He has a right, my lord, to make, my lord, a cinematograph film or a record in respect of the work. Then, my lord, kindly see, to communicate the work by radio diffusion or to communicate to the public by a loudspeaker or any other similar instrument, the radio diffusion of the work. To make any adaptation of the work, to do in relation to a translation or an adaptation of the work, any of the acts specified in relation to the work in clauses 1 to 6. Now, my lord, kindly come straight away to see, in the case of a cinematograph film, to do or authorize the doing of any of the following acts, namely, to make a copy of the film. So, my lord, we have a film, my lord, a copy is made. Simpliciter. My lord, one can authorize, my lord, many copies. Then, my lord, to cause the film, insofar as it consists of visual images, to be seen in public, and insofar as it consists of sounds, to be heard in public. My lord, exhibition of the film, what we refer to, my lord, as exhibition. Then, my lord, kindly see 3. To make any record embodying the recording in any part of the soundtrack associated with the film by utilizing such soundtrack. Now, my lord, we have, my lord, the Sholay soundtrack. My lord, we want, my lord, other than dialogues, my lord, we want some song from there. My lord, we use the soundtrack and, my lord, produce a record. Then, my lord, what about records? My lord? In the case of a record, to do or authorize the doing of any of the following acts. By what? By utilizing the record. Not anything else is being utilized. By utilizing the record. Namely, to make another record embodying the same recording. Then, my lord, to cause the recording embodied in the record to be heard in public. To communicate the recording embodied in the record by radio diffusion. And, my lord, any reference in subsection 1, translation, adaptation, my lord, is, my lord, Now, my lord, kindly have a look at ownership of copyright and the rights of the owner. Now, my lord, one important factor, my lord, before I place the sections, the lordship will notice that, my lord, author, there is a separation, my lord, between author and the first owner of the copyright. My lord, which is recognized in section 17. Now, my lord, kindly have a look at section 17. Again, subject to the provisions of the Act, the author of a work shall be the first owner of the copyright therein. So, my lord, generally, the author is the first owner of the copyright. So, if I write a book, my lord, I should be, my lord, the first owner of the copyright. Similarly, my lord, if I compose, my lord, any music, my lord, I am the first owner of that musical work, normally. But it's subject to the provisions of the Act. Now, kindly have a look at, provided that in the case of a literary, dramatic or artistic work made by the author in the course of his employment by the proprietor of a newspaper, magazine, or similar periodical under a contract of service or apprenticeship for the purpose of publication in a newspaper, magazine, or similar periodical, the proprietor shall, kindly note this, in the absence of any agreement to the contrary, be the first owner of the copyright in the work insofar as the copyright relates to the publication of the work in any newspaper, magazine, or similar periodical, or to the reproduction of the work for the purpose of it being so published. But in all other respects, the author shall be the first owner of the copyright in the work. Let us say, Millard, an editorial is written, Millard, by Millard, an author, Millard, under a contract of service, Millard, in a particular newspaper. Then Millard, though he is the author of the piece, Millard, for certain rights given to the owner of a copyright, he is not the first owner of the copyright. It is the proprietor of the newspaper. Unless there is, Millard, a contract to the contrary. Now, Millard, kindly have a look at B, Millard. Subject to the provisions of clause A. Again, in the case of a photograph taken or a painting or portrait drawn or an engraving or a cinematograph film made for valuable consideration at the instance of any person, such person shall, in the absence of any agreement to the contrary, be the first owner of the copyright therein. Now, Millard, this is in addition to Millard 17A. Millard, artistic work includes a photograph. Under the definition, Lordship may see that 2C, artistic work. So, Millard, A covers literary, dramatic, or artistic work. It would belong to the proprietor. But subject to the provisions of clause A, in the case of a photograph taken or a painting or portrait done, or an engraving on a cinematographic film made for valuable consideration at the instance of any person, such person shall, in the absence of any agreement to the contrary, be the first owner. So, my lord, the producer, my lord, will become, my lord, the owner of all this. Now, my lord, kindly see C. This is, my lord, omnibus. In the case of a work made in the course of the author's employment under a contract of service or apprenticeship, now kindly note this, to which clause A or clause B does not apply, the employer shall, in the absence of any agreement to the contrary, be the first owner of the copyright. My lord, all that I'm drawing your lordship's attention to is that, my lord, the author, in all cases, my lord, is not the first owner of the copyright. And, my lord, unless there is an agreement to the contrary, my lord, if, my lord, the author, my lord, has, my lord, done any work, my lord, under, my lord, a contract of service, the employer, my lord, is, my lord, the owner. The first owner, my lord, of, my lord, the copyright. Now, my lord, kindly come to, my lord, section 18. My lord, 18 and 19, my lord, I will deal with when doing the new act. It shows what the earlier provisions were. So, my lord, they're just additions, my lord, which I shall deal with then. Now, my lord, and my lord, 33 to 35, my lord, of the old act related to, my lord, copyright societies.
But it seems, my lord, the sound of music is going to keep your lordships enthralled for quite some time.
Ask Mr. Mukherjee.
No, I won't be able to conclude today, but in case your lordships,
No, then we can, because
Yes.
Mr. Mitro wouldn't be knowing that we had, on the last occasion, we had directed that these matters be listed above the gas matter. But by mistake, in the list, they have been printed.
We did not know.
Yes. So we'll continue till 12 o'clock?
yes, ma'am.
Then we'll take up your matter at 12?
হবে না মনে হয়।
হবে 12টায় বলুন।
12টা পর্যন্ত রিলিজ করুন।
না না 12টায়
But
নেবে।
if you are going to
না না
come
12টায় নেবে।
We'll take up your matter at 12.
Yeah.
Because that's the first matter after this.
Yes, quite.
First specially assigned, yes.
Mr. Banerjee is, my lord, sitting there quite comfortably, hoping that this matter will continue for.
No. I also wanted the other.
We should come back.
I wanted the gas matter.
He doesn't want flaring up of the gas.
He is quite content with the music.
12 o'clock, we'll take up your matter.
Lordship.
Now, my lord, on this interplay of sections, and my lord, as to first owner of copyright, my lord, Calcutta High Court had taken the lead. My lord, under my lord, the 1957 Act. Now, my lord, I also fervently hope, my lord, Calcutta High Court would take the lead amongst, my lord, division benches, my lord, hearing this issue. The matters pending in Delhi, before the division bench, matters pending, my lord, in, my lord, Bombay High Court, and, my lord, before the Calcutta High Court. On this issue, my lord. I'll place those orders, my lord, as well. My lord, Delhi is, I think, the
Mr. Banerjee is dealing with gas. You aren't.
my lord, I'm being pumped by him.
Yes.
Now, my lord, kindly come straight away, my lord, to All India Reporter 1974, Calcutta 257. My lord, which is also reported in 1974 SCC Online, Cal 14. My lord, it's a division bench judgment. Kindly come to paragraph 3. My lord, this was the issue involved. The main question, therefore, is whether the composers of lyric and music, in fact, have a copyright in the musical works incorporated in the soundtrack of a cinematography. Now, my lord, kindly come straight away, my lord, to paragraph 15, my lord, which is, I believe, my lord, in print page, my lord, 3. The ownership of copyright and the rights of the owner have been prescribed in Chapter 4 of the Act. Section 17 is the first section in this chapter. The relevant portions of Section 17 are as follows. Now, my lord, I place this. Kindly come to para 16. From this section, it appears that when a cinematograph film is made at the instance of any person for valuable consideration, such person is the first owner of the copyright in the film, unless the writer of the story or the artist who takes part in the film or the composer or performer of music by an agreement to the contrary has reserved the copyright. Clause C of Section 17 is a general clause. That clause also indicates that the employer under a contract of service is the first owner of the copyright. Then, my lord, the next section to be referred to is Section 30. By this section, it is provided that the owner of the copyright in any existing work or the prospective owner of the copyright in any future work may grant any interest in the right by license in writing signed by him or by his duly authorized agent. In the case of a license relating to copyright in any future work, license shall take effect only when the work comes into existence. Then, my lord, 33, my lord, IPRS, my lord, is referred to. Then, my lord, para 21. On a conspectus of the various provisions of the Copyright Act, we have referred to the following conclusions, it appears to us, can be reached. The owner of a cinematograph film, which includes the soundtrack, is the author of the film. As the author of the film, the owner, in the absence of an agreement to the contrary, is the first owner of the copyright in the film. Since he is the first owner of the copyright in the film, including the soundtrack, he has the exclusive right to do or authorize the doing of the following acts. Millard, I've placed this also 14(1)(c). Then Millard, 4. If a cinematograph film is produced at the instance of any person for valuable consideration, that person and that person alone, in the absence of an agreement to the contrary, shall be the first owner of the copyright, and those who participate in it or contribute to it for valuable consideration do not acquire any copyright at all. Kindly note this. The opening sentence of section 17 makes it clear that the author of a work shall be the first owner of the copyright therein, subject to the provisions of this act. And proviso B to section 17 prescribes that in a cinematograph film for valuable consideration, at the instance of a person, such person shall, in the absence of an agreement to the contrary, be the first owner of the copyright therein. There is a marked difference between proviso A, B and C to section 17. Proviso A creates two copyrights, one for the proprietor of a newspaper, magazine or similar periodical, and the other in favor of the author in all other respects. Lordship seen Millard, 17, Millard, A, Millard, for some purposes, the proprietor is Millard, the owner of the copyright. But in provisos B and C, a person under a contract of service for valuable consideration acquires no copyright at all in the absence of an agreement to the contrary. Now, Millard, even if we assume that a composer of music running commentary. Even if we assume that a composer of music who participates in the production of a film that is produced for the first time also acquires a separate copyright, the composer's copyright does not destroy the copyright of the author of the cinematograph film. The author has the exclusive rights described in section 14(1)(c). Then, Millard, at this stage, it would be relevant to refer to so and so. Millard, kindly I'll just place some of them. Millard, it's still para 33, but Millard, I'll just place, Millard, some of them. It's 21 to 33, some of them. At this stage, it would be relevant to refer to subsection 3A of section 13 of the Act. It says that copyright shall not subsist in any cinematograph film if a substantial part of the film is an infringement of the copyright in any other work. This subsection is not attracted to a case in which the composer of music for valuable consideration composes for the first time at the instance of any person for the purpose of reproduction. Subsection 3 of 13 deals with a case where copyright already subsists and without the license or permission of the owner of the copyright, subject matter is brought. This would be an instance. Then, Millard, kindly come to Millard para 24. Mr. A.K. Sen, learned counsel for the respondents, has submitted to us that the copyright in a musical work belongs to the composer of the music or his assignee. This right may be an existing right or a right in a future work. In the instant case, the terms of assignment in favor of IPRS covers not only existing right but also rights in future works of the assignor. In these premises, the film producer needs the permission. Kindly see, in these premises, a film producer needs the permission of IPRS to perform the musical work in public, and without a license granted by IPRS, public performance is illegal inasmuch as copyright in musical work means the exclusive right, so and so. Then Millard Coppinger is Millard relied on. Millard, kindly come to para 27. So Millard, we have a producer of a film. Now Millard, he plays Millard the sound. They say, sorry, you have to have the license of the Millard, owner of the work in the musical works. Kindly see. We are unable to accept the contentions of Mr. Sen. We have already pointed out that a cinematograph film includes the soundtrack, section 2F, and an author to a relation is the owner of the film at the time of its section 2. In Coppinger, in Article 7, it has. Then Miller 28. A cinematograph film therefore includes the sounds embodied in a soundtrack, and sound means anything perceived by the ear. So and so. The music in the soundtrack is therefore a pan-land parcel of the cinematograph film itself. A composer of music can assign his copyright only when he shows that he has either an existing right or a right he would acquire in future. In the case of a cinematograph film, now kindly mark this, when he composes for the first time for valuable consideration, he has no existing right, nor does he acquire any further right in the absence of an agreement to the contrary. The Act makes it clear that a cinematograph film includes soundtrack, and soundtrack means so and so. The composer of music for valuable consideration, as aforesaid, therefore can have neither any existing right nor any future right unless he enters into an agreement to the contrary, which he can assign or is capable of assigning. Then Mr. Sen, learned junior counsel, placed reliance on a passage from Millard, 1934, 1 Chancery 450. Then kindly come to para 30. Mr. S.C. Sen's point on the facts of this case is that the moment there is an original composition, it is saddled with a copyright in favor of IPRS under proviso to section 18. The law prevents the composer from bringing into existence anything which is not assigned to IPRS. From this point of view, cinematograph film owners' copyright in the soundtrack cannot be borne, inasmuch as before it could be borne, it stood assigned to I. This argument, on behalf of the respondents, we are also unable to hold. An assignee cannot have a right higher than the right of an assignor. A composer of music for valuable consideration who composes for the first time for the cinematograph film does not acquire any copyright in the music unless there is a contract to the contrary. Section 17 is the only section that speaks of first owner of copyright, and under proviso B in a cinematograph film, first owner is the person at whose instance the film is made. Then Millard, para 33. In our opinion, therefore, when a composer of lyric or music composes for the first time for valuable consideration for the purposes of a cinematograph film, the owner of the film at whose instance the composition is made becomes the first owner of the copyright in the composition. So, my lord, the producer, my lord, he also owns the copyright in the musical work and the literary work. The composer acquires no copyright at all, either in respect of the film or its soundtrack, which he is capable of assigning. In these circumstances, assignment of any of the copyright in any future work is of no effect. The composer can claim a copyright only on the basis of an express agreement reserving his copyright between him and the owner of the copyright. Now, Millard, matter Millard did not Millard end there. It went to the Supreme Court. You kindly have a look at Millard, the decision of the Supreme Court, reported in Millard 1977, 2 Supreme Court cases. Millard 820. Millard, kindly take Millard paragraph 1 first. This appeal by certificate granted under Article 133 of the Constitution by the High Court should be at Calcutta, which is directed against, raises the following substantial question of law. of general importance. Whether in view of the provisions of the Copyright Act 1957 and existing and future right of music composer, lyricist is capable of assignment, and whether the producer of a cinematograph film can defeat the same by engaging the same person. Now, Millard, kindly turn to Millard paragraph 8. Millard, this question, Millard, had two parts. Now, Millard, paragraph 8, Millard, is Millard dealing with the second part. It is the second part of the question, which has been a hotbed of controversy between the parties, that has got to be tackled. The main point for determination in regard to this part of the question is whether the composer of lyrics or musical work, which in terms of section 2b of the Act means only a notionally written, printed, or graphically produced or reproduced music, retains a copyright in the lyric or musical work if he grants a license or permission to the owner of a cinematographic film for its incorporation in the soundtrack of a film. For proper appreciation and determination of the contentions raised before us, it is necessary to notice certain provisions. Now, Millard, the provisions, Millard, continue. Millard, and then all of which, Millard, I have placed. Other than Millard 22 and 26 and Millard 30. Millard, those are terms of copyright and Millard licenses by owners. Then Millard, kindly come to para 15 at page 830. The interpretation clause F of section 2, reproduced above, which is not exhaustive, leaves no room for doubt when read in conjunction with section 14(1)(c)(3) that the term cinematograph film includes a soundtrack associated with the film. In the light of these provisions, it cannot be disputed that a cinematograph film is to be taken to include the sounds embodied in a soundtrack which is associated with the film. Then, Millard, last 10 lines in that page, Millard, kindly take the right-hand side, section 13.4. Lordships have that. Section 13.4, on which Mr. Ashok Sen has leaned heavily in support of his contention, lays down that the copyright in a cinematograph film or a record shall not affect the separate copyright in any work in respect of which or a substantial part of which the film or, as the case may be, the record is made. Though conflict may at first sight seem to exist between section 13.4 and section 14(1)(a)(3) on the one hand and section 14(1)(c)(2) on the other, a close scrutiny and a harmonious and rational instead of a mechanical construction of the said provisions cannot but lead to the irresistible conclusion that once the author of a lyric or musical work parts with a portion of his copyright by authorizing a film producer to make a cinematograph film in respect of his work, and thereby to have his work incorporated or recorded in the soundtrack of a cinematograph film, the latter acquires by virtue of section 14(1)(c) of the Act on completion of the cinematograph film a copyright which gives him the exclusive right inter alia of performing the work in public, that is, to cause the film in so far it consists of visual images to be seen in public and so far as it consists of acoustic portion, including a lyric or a musical work, to be heard in public. Kindly note this. Without securing any further permission of the author of the lyric or musical work for the performance of the work in public. Then Miller. In other words, a distinct copyright in the aforesaid circumstances comes to vest in the cinematograph film as a whole, which in the words of British Copyright Committee set up in 1951 relates both to copying of the film and to its performance in public. Thus, if an author of a lyric or musical work authorizes a cinematograph film producer to make a cinematograph film of his composition by recording it on the soundtrack of a cinematograph film, he cannot complain of the infringement of his copyright if the author, that is owner of the cinematograph film, causes the lyric or musical work recorded on the soundtrack of the film to be heard in public, and nothing contained in section 13(4) of the Act on which Mr. Ashok Sen has strongly relied can operate to affect the rights acquired by the author owner of the film by virtue of section 14(1)(c) of the Act. Then, my lord, the composer of a lyric or a musical work, however, kindly note this, retains the right of performing it in public for profit otherwise than as part of the cinematograph film, and he cannot be restrained from doing so. So, my lord, here's, my lord, the author, my lord, of a music or literary work, who, my lord, owns the copyright in the work to start with. Then, my lord, he consents, my lord, to that being incorporated, my lord, in a cinematograph film. My lord, the producer, my lord, is the owner of the copyright. If he communicates the sound or the visual images which are in the soundtrack, my lord, it's not an infringement of the author's right. My lord, the my lord, author, my lord, of the musical work, or my lord, the lyricist. Now kindly see, my lord, what happens then. But, my lord, that work, that musical work, my lord, that, my lord, literary work, my lord, can be performed. And, my lord, the author may, my lord, earn royalty, my lord, by permitting that to be done. It's otherwise than, my lord, the cinematograph film, without using its soundtrack. Now, my lord, kindly see. In other words, the author, composer of a lyric or musical work who has authorized a cinematograph film producer to make a cinematograph film of his work and has thereby permitted him to appropriate his work by incorporating or recording it on the soundtrack of a cinematograph film cannot restrain the author, that is owner of the film, from causing the portion of the film to be performed or projected or screened in public for profit, or for making any record embodying the recording in any part of the soundtrack associated with the film by utilizing such soundtrack, or from communicating or authorizing the communication of the film by radio diffusion of so and so, expressly permits the owner to do all these things. Now, Millard, kindly come to 17. Page 832. This takes us to the core of the question, namely, whether the producer of a cinematograph film can defeat the right of the composer of music or lyricist by engaging him. Now, my lord, first case scenario, they had, my lord, copyright, which, my lord, they permitted the works to. Now, my lord, here, kindly see, my lord, can this right of owning, my lord, the copyright, or being the, my lord, owning the copyright be defeated? Kindly see. The key to the solution of the question lies The key to the solution of the question lies in provisos B and C to section 17 of the Act reproduced above, which put the matter beyond doubt. According to the first of these provisions, namely proviso B, when a cinematograph film producer commissions a composer of music or a lyricist for reward or valuable consideration for the purpose of making his cinematograph film or composing music or lyric therefore, namely the sounds for incorporation or absorption in the soundtrack associated with the film, which has already indicated are included in a cinematograph film, he becomes the first owner of the copyright therein, and no copyright subsists in the composer of the lyric or music so composed, unless there is a contract to the contrary between the composer of the lyric or music on the one hand and the producer of the cinematograph. The same result follows according to aforesaid proviso C if the composer of music or lyric is employed under a contract of service or apprenticeship to compose the work. It is therefore crystal clear that the rights of a music composer or lyricist can be defeated by the producer of a cinematograph film in the manner laid down in provisos B and C of section 17 of the Act. We are fortified in this view by the decision in Wallersteiner and Herbert relied upon by Mr. Shochin Chaudhary, wherein it was held that the music composed for reward by the plaintiff in pursuance of his engagement to give effect to certain situations in the drama entitled Lady Andley's Secret, which was to be put on the stage, was not an independent composition, but was merely an accessory to and a part and parcel of the drama, and the plaintiff did not have any right in the music. Then, my lord, for the foregoing reasons, my lord, the appeal, my lord, was not, my lord. Now, the footnote, my lord, is of some importance because fair amount of submissions were made, my lord, in respect of this footnote to justify, my lord, the interpretations which have been given, my lord, to the amendment introduced to the Act in 2012. Now, my lord, this is Justice Krishna Iyer's judgment. Kindly give me a minute, my lord. I'm just waiting for the noise to die down. The judgment just delivered is on behalf of the court, which makes this footnote in a sense odious. So, my lord, the judgment is, my lord, by my lord Justice Jaswant Singh, and my lord, that is, my lord, acknowledged by Justice Iyer. But I do append the abbreviated opinion solely to belight a slightly penumbral area of the law and to voice a need for legislative exploration to protect a category now left in the court. Now, my lord, kindly come to, my lord, para 20. My lord, since, my lord, there's felicity of expression here, my lord, I will, my lord, deal with the sentence which, my lord, deals with a felicitious blend. A cinematograph film is a felicitious blend, a beautiful totality, a constellation of stars, if I may use these lovely imageries to drive home my point, slurring over the rule against mixed metaphor. Cinema is more than long strips of celluloid, more than miracles in photography, more than song, dance, and dialogue, and indeed more than dramatic story, exciting plot, gripping situations, and marvelous acting. But it is that ensemble which is the finished product of orchestrated performance by each of the several participants, although the components may sometimes in themselves be elegant entities. Copyright in a cinema film exists in law, but Section 13(4) of the Act preserves the separate survival in its individuality of a copyright enjoyed by any work, notwithstanding its confluence in the film. This persistence of aesthetic personality of the intellectual property cannot cut down the copyright of the film, qua film. Then, my lord, para 22, my lord, kindly take. The creative intelligence of man is displayed in multiform ways of aesthetic expression, but it often happens, kindly note this, that economic systems so operate that the priceless divinity, which we call artistic or literary creativity in man, is exploited, and masters whose works are invaluable are victims of piffling payments. World opinion in defense of the human right to intellectual property led to international conventions and municipal laws, commissions, codes, and organizations calculated to protect works of art. India responded to this universal need by enacting the Copyright Act. Then, my lord, para 24, what I was, my lord, pointing out to your lordships, my lord, not that it was original thinking, it was from here, my lord, kindly see. A somewhat un-Indian feature we noticed in the Indian Copyright Act falls to be mentioned. Of course, when a law is intellectual borrowing from British reports, as admittedly it is, such exoticism is possible. Musical work as defined reads. Then, my lord, therefore, copyrighted music is not the soulful tune, the superb singing, the glorious voice, or the wonderful rendering. It is the melody or harmony reduced to print, written, or graphic form. The Indian music lovers throng to listen and be enthralled or enchanted by the Nada Brahma, the sweet concord of sounds, the raga, the bhava, the laya, and the sublime or exciting singing. Printed music is not the glamour or glory of it by and large, although the content of the poem or the lyric or the song does have appeal. Strangely enough, author as defined in 2D in relation to a musical work is only the composer, and section 16 confines copyright to those works which are recognized by the Act. This means that the composer alone has copyright in musical work. So, Millard, since because of the definition of music, Millard, in the Copyright Act, it's the composer alone, Millard, who is Millard, recognized Millard as the owner of copyright. Millard, the grievance being voiced, Millard, in this footnote is, Millard, as far as Indian music is concerned, Millard, it is much more, Millard, than Millard, the composer. So the Millard provisions of the Act need to be, Millard, addressed. Millard, so Millard has to provide for Millard the Millard superb singing, the tune, the voice, and the rendering. Now, Millard, kindly see. This means the singer has none. Now, Millard, after that, the singer has none. This disentitlement of the musician or group of musical artists to copyright is un-Indian, because the major attraction which lends monetary value to a musical performance is not the music maker so much as the musician. So, my lord, really crying out, my lord, for the performer's rights. Perhaps both deserve to be recognized by the copyright law. I make this observation only because art, in one sense, depends on the ethos and the aesthetic best of a people. And while universal protection of intellectual and aesthetic property of creators of works is an international obligation, this is important. Each country in its law must protect such rights wherever originality is contributed. So viewed, apart from the music composer, the singer must be conferred a right. Again, my lord, performers' rights. Of course, lawmaking is the province of parliament, but the court must communicate to the lawmaker such infirmities as exist in the law extant. This was the footnote. Otherwise, my lord, it's the judgment of the court, my lord, was delivered by my lord, Justice Singh. My lord, for both. Now, my lord, kindly come to my lord, the next round, my lord, under my lord, on this, my lord, 1978 SCC, online Calcutta 121. My lord, this is also our division bench. My lord, just kindly make a note, my lord, in para 12, 13 and 14, my lord, it's really, my lord, accepting, my lord, I mean, there's no option that, my lord, the Supreme Court decision which I cited, my lord, was, my lord, the law and would, my lord, govern the relationship, my lord, of the parties. Now, my lord, there were amendments my lord, to the Copyright Act, my lord, from time to time. My lord, it happened, my lord, in 1984. I'm just giving the years, my lord. 1984, my lord, 1955, 1995, 2012, and 2021.
Please, once again, please. 19.
My lord, 1984, my lord, your lordships have. Then 1995, 2012, and 2021. The 60 কত তে ছিল 63 তে ছিল. That's including territories. Now, my lord, kindly take, my lord, section new.
Mr. Mukherjee, you may want to stop here
Yes,
today. We'll rise and come back and take up
yes,
Mr. Jayanto Mitra's matter.
my lord, this matter next on
Tell us, Friday?
Friday or Monday, whatever.
Friday?
My lord, Friday, my lord, my learned junior has a problem. Could it be on Monday?
Monday.
So the only thing is, my lord, অসম্ভব হয়ে যাচ্ছে. 4 times, my lord, time was taken, my lord. I
So
think
they
we are
took
in
time 6 times before that. Am I pointing that out?
What lecho? Hey. Mr. S.N. Mukherjee, learned senior counsel, appearing for the appellant in all the three appeals. একসঙ্গে হচ্ছে কি? Separate?
My lord, I'm addressing my lord on all. My lord.
On all? So it can be a common order,
Yes,
common
yes,
judgment.
yes, yes.
Common করে দেওয়া হবে. In all the three appeals, appearing for the appellant, all the three appeals, begins his submission but does not conclude. Paragraph lists these matters once again. Monday did the retaining is at the same position. At the same
I'm
position.
grateful.
Well, maybe we just file, my lord, the compliance affidavit. This is, my lord, pursuant to, my lord,
Pursuant to orders, my lord, we have to.
Paragraph compliance affidavit. Is that how you've
Just
described?
getting, my lord, the money, my lord, for
Compliance
Right.
affidavit filed on behalf of the appellant be kept with the records.
Great.
ঘুরে এসে মিত্র সাহেবের নাম থাকবে
Is the assignment item number 4? এটা কোথায় সাথে কোথায় থাকবে TCR
What you had last said,
yes my lord.
layering up was recorded as 28.4% in the annual report for financial year 2015-16.
Correct.
This was noted by the CCI in its order.
Yes, Lord, I was submitting, my lord, on the fact that, my lord, it was there in our financial records, and, my lord, we'll recall, my lord, one of their employees, which was considered, my lord, as a challenge by them only to, my lord, the clauses in, my lord, the agreement in the GS, my lord, the gas supply, gas sale and purchase agreement.
The
So-
NGNG clause and all.
Yes, they were all challenged, my lord, saying, my lord, it's anti-competitive, and, my lord, in that context, my lord, certain, my lord, findings were given by, my lord, initially, my lord, knows, my lord, in the Competition, my lord, Act, first it goes through the Director General for investigation, then, my lord, the CCI, and then, my lord, either the Competition, my lord, appeal, my lord, before, my lord, now, my lord, it's the NCLAT. Otherwise, my lord, it comes, my lord, as by way of a writ petition, my lord, before the High Court, which is what, my lord, happened here. Now, my lord, the CCI order is very important. In that context, well, this is dated 16 December 2017. Well, it was made a part of, well, their submissions of 8 January 2025.
Order dated? Dated?
Well, the CCI orders dated 16 February 2017. And, well, the document is না এটা আমাদের কম্পিলেশন এটা দেখুন ওরা দিয়েছে এরকম ভাবে দাস লিগ্যালের 8 January 2025 হ্যাঁ এখানে কিভাবে থাকে ও হ্যাঁ রোড নোটস হ্যাঁ হ্যাঁ Now, this one will kindly take page 88, where that order starts Competition Commission. But first one will kindly come to paragraph 1. The present information has been filed by Saurabh Tripathi, the informant under section 19(1)(a), the act against GECL opposite party alleging inter alia contravention of provisions of section 4 of the act, 4 of the Competition Act. Then kindly come to paragraph 4. The informant is an employee of SRMB Srijan Limited, which is one of the appellant here. A company provision under the sunset described leading rolling mill comprising 2 rolling mills based out of Durgapur, Bardhaman district. Then kindly come to 5. It is stated information GECL a dominant position relevant market of supply and distribution of CBM gas in Asansol running as Durgapur belt. Further, it is alleged that GECL by abusing its dominant position relevant market has put unconscionable terms and conditions in its gas sale and purchase agreement GSPA executed with the buyers such as SRMB. Informant has alleged that GECL, besides imposing unfair conditions upon the buyers, also charging unfair and discriminatory prices. Alleged abusive terms have been detailed in the information. Then, kindly come to paragraph 7. This matter was referred to the Director General with the order dated 29 December, passed under section 26(1) of the Act for investigation with direction to submit investigation report. Accordingly, DG conducted investigation and submitted investigation report on 29 December 2015. Then, Paragraph 8, to investigate matter, DG took the relevant matter as supply of CBM gas to industrial customer in area of Asansol, Raniganj, Durgapur area. In this relevant market, the DG concluded that OP has been in a dominant position during 2009 to 2012. Then, my lord, kindly straight away come to paragraph 35 at page 100. Issue number 2, really, my lord, paragraph 34 onwards. The DG found OP to be in a dominant position, relevant market for supply of CBM to industrial customers in Asansol, Raniganj, Durgapur industrial area. Challenging the findings of DG on the issue of dominance, OP, in line with its stance in the relevant market, argued that GECL is not dominant in the wider energy market. In the relevant market identified by GECL, its market share is 0.040% by volume of the overall energy market. GECL is a relatively new entrant in a market dominated by established fuel suppliers such as CIL, IOCL, BPCL, and HPCL. It has no financial strength compared to these players who possess huge resources. GECL has incurred significant capital expenditure, approximately 1560 crores, which it is yet to recover, and its net cash generation is still negative. Out of approximately 1076 industrial units in this area, GECL has only 33 customers as of 2011-12. Further, it was submitted that DG should have also examined the issue of dominance post 2012 when SR entered the market and garnered a significant market share in a short span of time. Without prejudice to GLC's position that the relevant market is wider, it was argued on behalf that there are several defects in the DG's analysis of dominance, even in the so-called narrower CBM market. Then 37, in this regard, it was submitted GCL cannot act independently of its customers. DG has failed. This is the challenge to the DG's finding on the question of dominance. DG has failed to satisfy definition of dominance under the Act as GCL not able to act independent of customers, as evidenced by the fact that even smaller customers are able to negotiate terms and conditions with GCL. Evidence has been summarily rejected DG. Further, GCL cannot dictate terms even to smaller customers. We've seen analysis of the prices agreed with the top 10 and top 10 and bottom 10 customers GCL. This shows that all the GCL's top 10 customers and 7 out of 10 of GCL's bottom customers have had negotiated fixed price arrangement. That is, the price of gas is fixed for a certain period of time before being renegotiated. This shows countervailing buyer power. The GCL not able to squeeze the different terms to small, leaving aside the big customers. Then 38, OP has negotiated. 38 is important. Significantly, OP has referred to the negotiations held with SRMB. It was pointed out GCL offered the draft GSPA for SRMB's comments. There were as many as 5 versions of GSPA that were exchanged between GCL and SRMB. SRMB had full opportunity to raise the concerns it has in relation to the clause of GSPA during this negotiation. It was only after detailed negotiation with SRMB that GSPA was finalized on 11th May 2011. In fact, perusal of GSPA would show some of the last minute handwritten changes made by SRMB, including an exit option after 1 year. Then 39, it was further contended SRMB was not in a take it or leave it situation. There was a fundamental logical inconsistency in the informant's story. Informant is attempting to give a picture that after incurring loss of switching to CBM gas, SRM was locked in. GCL explained the situation. But we can just skip over this and kindly come to paragraph 40. Dominant position, really not 41. Lastly, on the issue of dominance, very important, 104. It was submitted that GECL has no financial strength. The DG has, this is very important, has relied on financials as reported in the annual reports to show GECL's financial strength. Mere profitability on the books of accounts cannot lead to an inference of dominance. A more accurate measure is the net cash generation, which has been negative till date for GECL. This shows that GECL is still in the process of recovering its initial capital investment. Further, GECL has had to flare up 28.48% of the gas produced in 2015-16 as it had no market for the same in the face of competing products. So the second sentence was not saying DG has relied on financials reported in annual reports to show GECL's financial strength. That's not where the figure comes from. And today, admitted position is, they also say there's been flaring up. But they give up to 2014. they do not give the financials, my lord, of 2015-16. And I had shown, my lord, the line which was taken out of context.
This, Mr. Mithro had said, is part of your submission before the CCI.
Yes, but my lord, the finding is, my lord, of the DG. The my lord looks at the DG, because I'm challenging the finding of DG. At paragraph 41, my lord will find, lastly, on the issue of dominant, it was submitted that GECL has no financial strength. The DG has relied on financials as reported in annual reports to show GECL's financial strength. So it is, my lord, a finding of the DG from my financial statements.
Do we have DG's findings on record?
No, my lord, that is not there.
It's not there.
That is not there. It's a challenge to the DG's finding. I mean, not that, my lord, this makes a really, my lord, so much of a difference. Because now that, my lord, what I've submitted on the question of, my lord, damages, well, I think, my lord, with great respect, my lord, perhaps, my lord, the other side, my lord, what, my lord, has been submitted by the appellant is not the correct measure of damages at all. I said, as long as I have gas, I've lost that bargain. Just because the gas which was to be supplied to you was supplied to someone else doesn't mean that I could not have also supplied gas to you. And, my lord, I'll show, my lord, the example which I was giving. My lord, my junior Mr. Mukherjee, he was very excited. He found a case, my lord, exactly on that example. On the car example. He was really excited. He showed me and said, look, this is what you've been really submitting on the question of cars. It's a old, my lord, English case, my lord, which actually, my lord, says this is exactly, my lord, when I come to that judgment, I'll just show that. So I'm on the question, my lord, that two things. First, my lord, your own case, when you rely on part 4 of the argument, my lord will recall, you say that the flaring up has been less than what it was previous year. So one thing implicit in that, you are admitting there is flaring up. 2, you have not shown, and which is what you have to show for me to only get nominal damages, because let us, we have assumed breaches there, that there was no further supply of gas available. Because I have X and Y customer. X goes away. Z comes in. That doesn't mean X's breach goes away. I would have then had X, Y, and Z as customer. So the loss which I have from X continues.
And in contract, different from tort, the damages would be such as would put you in the same position had the contract been performed.
Absolutely. That's the.
This is what you are saying.
Correct. That's the difference, my lord, between a contractual grant of damages and a tortious. Tortious, my lord, is when I am put back in the situation where the tort would not have happened.
Yes.
So the principle is that, my lord, whatever I've suffered as a result of your injury, a tortious act.
Doesn't matter, I have made profit by selling to others.
Correct. I would have made profit from you also.
If the contract had been performed.
I just want to, my lord, show that judgment, my lord, but this absolutely, my lord.
What was that book, Mr. Banerjee, Remedies in Tort and Contract? Burroughs. Did you ever read Burroughs? You know?
Burroughs will not be had, but that was, my lord, for better students. We had only, my lord, Dias and Marcus and taught. And, my lord, right.
Chance dilam oke Yes.
Not, my lord, everything, my lord.
Remedies in খুব ভালো বই হঠাৎ মনে হলো remedies in tort and contract. Many principles.
In fact, Malad, Chitti, Mr. Mitra has relied on a portion of Chitti. Chitti also, Malad, says exactly, Malad, what I'm saying. And I'll show it from his the paragraph passage, Malad, which is read out. That also says exactly the same thing. But Malad, since we are on this, Malad, this is I'm just, Malad, I wouldn't have shown judgments, Malad, now in the middle of this, but I just think, Malad, this is an appropriate time, Malad, just to show this. This is, Malad, 1955, 2 weekly law reports. Malad, also, Malad, দিয়েছি স্যার maybe Malad, this may be a good time, Malad, just to show that. So my example which I keep on, it is also reported, Malad, 1955 1 All England report 154. Malad, just as 55 1 All England reports, page 154. Chancery Division, Malad, Justice Upjohn. If I remember correctly, Malad, it was not a, it was a commercial, Malad, judge as well. Kindly see this action, Malad, I'm just reading from the judgment itself. Or Malad, just before the judgment, Malad, the argument, kindly look at, Malad, the argument is internal page 3. It was also common ground. This is part of the arguments that at this stage, the plaintiffs lost a sale in the sense that if another purchaser had come into the plaintiff's premises, there was available for another purchaser a Vanguard car for immediate delivery. So that the effect on the plaintiff was they had lost their profit on a sale, having sold one Vanguard less than they would have otherwise have done. Plaintiffs contended that the true measure of damage in the circumstances was no more and no less than the loss of profit, namely 61 pounds. Defendant said that the loss was nominal, for the plaintiffs would have sold the car to another customer or could do what in fact they did, get their suppliers to release them, and they had thus suffered no damages. So what here, Malad, they had the sale was of, Malad, a Vanguard car. They had returned, when they refused, Malad, they returned it to, Malad, their suppliers, manufacturers. So defendant took a defense saying you have not suffered any loss because you've returned it.
So the claim was for 61 pounds.
That is the
That's the loss of, Malad.
loss of commission for the car.
55, Malad, I would imagine, Malad, would be, Malad, at least, Malad, 600.
In 1959, the fees at LSE was 50 pounds a year. When my
1990.
When my learned friends went
It was
to London, at
600.
LSE the fee had
No.
become 2,000.
No, sir.
More.
5,500.
Yes, yes.
5,500
Rose to 6,000.
rose to
Ah.
6,000 pounds.
And it went
Now,
on
Malad,
increasing.
Now I am told it is about 39,000 pounds
For the entire course or per year?
per year.
25,000.
Per year.
That's crazy. Absolutely.
So
And this is only the
ছোট ছেলে কিংস কলেজে 26,000 থেকে শুরু হয়েছিল এখন
so I'm right. So I'm right.
really, Malad?
So I told my father when I came back, I say, you have done it a rather cheap bargain on me. 50 pounds. Of course, 50 pounds had value at that point of time. But 50 pounds, 6,000 pounds, and now 39,000 pounds.
And how much would you spend on your monthly boarding and lodging?
We had, my lord, a ceiling of 300 pounds per year. We could not get it at that time.
Reserve Bank.
Reserve Bank. Reserve Bank only allowed 300 pounds. So, my lord, we had been a bit of a tight position. So, my lord, we had to work during holidays. I used to work either in the post office or in some hotel, my lord, as the bellboy, or, my lord, behind the bar. So behind the bar was much
bar
more
was-
interesting.
Behind the bar.
Yes, behind the bar.
Only working.
From behind
In
the
fact,
bar.
we were not permitted to work officially. Now they have changed the rules.
You could work for your college, you know.
College.
College library.
Again, Malad, yes. But now, Malad, I found Malad, they've changed the rules. You have a 12 hours per week. If you want to work, you can work.
Okay.
That's stamped on their visa.
আমাদের সময় কোনো restriction ছিল না।
আমাদের সময় পুরো restriction ছিল. We could not work. Could not work.
Yes.
Then Malad, just Abjan's judgment. This action raises a question of some importance to the motor trade as to the true measure of damages where the buyer of a motor car in this case, a standard Vanguard, refuses to complete his bargain and take delivery. His lordship stated the facts and continued the law is not really in doubt. It is set out in section sunset of the Sale of Goods Act. Then Malad, kindly come to page 5.
No, read that quotation at the bottom of page 3. Is from another case.
Yes, 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 Malad, sorry, I'm absolutely. From the speech of Lord Holden in British Westinghouse Electric Manufacturing Company was Underground Electric Airways Company, where he said this. Subject to this observation, I think there are certain broad principles which are quite well settled. The first is that as far as possible, he who has proved a breach of a bargain to supply what he contracted to get is to be placed, as far as money can do it, as good as a situation as if the contract had been performed. That is the general rule. Apart altogether from authority and statute, it would seem to me, on the facts which I have to consider to be quite plain, that the plaintiff's loss in this case is the loss of their bargain. They have sold one Vanguard less than they otherwise would. The plaintiffs, as the defendants must have known, are in business as dealers in motor cars and make their profit in buying and selling motor cars. And what they have lost is their profit on the sale of this Vanguard. There is no authority exactly in point in this country, although it seems to me that the principle to be applied is a clear one. It is to be found in Revic Mill Limited. In that case, the supplier, that's 1913 Chancery. In that case, the supplier was to supply certain machine which he had to make, and they were to be made to the particular specification of purchaser, although they were of a type generally in common use. Not the present case of a sale by a motor dealer of a standardized product. The purchaser repudiated his order and with view to mitigate damages, the supplier, getting another order for somewhat similar machine, very sensibly made such alterations as were necessary to the machinery that he had made for the original purchaser, and sold the machinery so altered to the second purchaser. His costs of doing that were comparatively trivial. It was said by the supplier that the measure of his damages was the loss of his bargain. By the purchaser that the measure of damages was merely the cost of the conversion of the machinery for the second purchaser and his slight loss on the resale. Lord Justice Hamilton, after setting on the facts, said this: that was a reasonable mode of mitigating the damages, but it by no means follows that the damages are confined to the cost, a trivial one, of adapting the machines to the needs of the second customer, and the loss on resale to them, which was only 23 pounds, making 28 in all. The fallacy of that is in supposing that the second customer was a substituted customer, that had all gone well, the makers would not have had both customers, both orders, and both profits. In fact, what they did, acting reasonably, and I think very likely more than reasonably in the interest of the Vic Mill, was to content themselves with earning the profit on the second contract at the cost of adapting the machines, which has been taken at 5 pounds. But they're still losers of the profit, which they would have made on the Vic Mill contract, because they could, if they had been minded, have performed both the contracts and have made the profits on both the contracts, but for the breach by the Vic Mill of their contract. This is exactly the situation. So that's why I said, even there's a little bit of flaring, that's good enough. And even if there was no flaring, then also it's good enough, but we don't have to travel to that extent because there was some flaring. And this is exactly the principle which we are looking. Lord Justice Buckley put the matter succinctly in this way: as regards number 1, where the goods were manufactured, the respondents are, I think, entitled to both profits because they were not bound to give the appellants the benefit of another order that the respondents received. The respondents were left with those goods on their hands. They altered them and sold them to another buyer, but they could have made and would otherwise, I suppose, have made other goods for the buyers, but they could not have made other goods for the respondents. This is exactly the principle which we are looking. Lord Justice Buckley put the matter succinctly in this way: as regards number 1, where the goods were manufactured, the respondents are, I think, entitled to both profits because they were not bound to give the appellants the benefit of another order that the respondents received. The respondents were left with those goods on their hands. They altered them and sold them to another buyer, but they could have made and not employed these goods for that purpose, if they had done so, they would have made both profits. It seems to me that in principle that covers this case. True, the motor car in question was not sold to another purchaser, but the plaintiffs did what was reasonable. They got out their bargain with George Thompson Limited, but they sold one less Vanguard and lost their profit on that transaction. In Re-Wick Mill Limited has been followed and applied to exactly the circumstances. I have therefore before me, that is to say, the sale of a motor car in a number of cases abroad to which have been referred in Cameron judgment on. This is very important also. Judgment of the Supreme Court of the State of South Australia head note reads, where a purchaser of a motor truck chassis from a dealer refused to accept delivery of the motor truck, which was then resold at a profit. Kindly see. There being evidence that similar motor trucks were available for immediate delivery, and the property not having passed, held that the seller was entitled to retain the profit on resale and also to damages for loss of profit on the original sale. How, my lord? And this is exactly, my lord, commercially. Unless, my lord, Mr. Mitra's client is able to show that I have no gas at all, my entire quantity was exhausted, I can't be deprived, my lord, then of the bargain which was made with him. Then there was Mason and Sons decision of appellate division, Supreme Court update. That, my lord, we can skip over and baki to hai. No. If a positive, there was no means of readily disposal. Well, there are some additional parts, my lord. I don't think, my lord, we need to, my lord, go into that. My lord, so, my lord, my submission is, my lord, I'm sorry, I just got out, my lord, and showed this judgment because I thought, my lord, very opposite, my lord, what, my lord, we were discussing. Now, my lord, coming back to my lord, coming back to my lord, the the Competition Commission order. My lord, 41 I have shown at page 104.
Page
104, my lord, of
Yes.
that, my lord, written notes. Paragraph 41 I had shown, my lord. My submission is, my lord, it appears, my lord, the DG had come to such a finding from our annual report, which 2015, 2016, my lord, we also have, because, my lord, it's not a part of record. I'm quite naturally, my lord, not producing it. But, my lord, it's a public record, my lord, we also have it, my lord, with us. Then, my lord, kindly come to paragraph 64. 64 term up for my lord, 64 at page 112, where, my lord, this clause is dealt with. Page 112, my lord.
Yes.
The clause dealing with quantity of gas, which inter alia deals with MGO liability of customers under GSPA, and which is alleged to be abusive by the informant, is as under. Then, my lord, clause 5.1 is set out. And, my lord, will find, my lord, 5.2, my lord, has the MGO clause also set out, 5.2, which is at page 113, which, my lord, I've already shown from before. Then kindly come to paragraph 65. DG noted that the MGO liability imposed on the customers by OP was both unfair and discriminatory. This is, my lord, what the DG had noted. Then kindly come to 67. This is, my lord, what the CCI holds. On a careful consideration of the matter, it may be observed that production of CBM gas production is a continuous process that starts once a well is dug and stops only when the well goes dry. GECL plans its productions based on the contracted quantity agreed with its customers on a long-term basis. Once the CBM is produced, it cannot be stored, and if the customer fails to take off the contracted quantity, GECL has no option but to flare up the gas. There is no spot market for CBM gas where GECL can sell the gas which is not consumed by a customer. MGO liability is a standard clause across most long-term supply contracts of producers and is intended to cover the risk of the seller in committing to sell a fixed quantity on a long-term basis and to assure the buyer of a firm supply of gas. Correspondingly, GECL is liable for a differential fuel cost under SRMB's agreement if its supply falls below the MGO level, and therefore the clause is equitable. DG's reasoning suffers from a flaw, as in the gas contracts of other gas suppliers, upstream suppliers who impose MGO liability are producers themselves. There is no question of discrimination if one considered the GCL's contracts are negotiated with each individual customer, and that SRMA did not raise the issue regarding MGO liability at the time of signing GSPA. It was only after SRMB had signed an agreement with SR, it requested for a waiver of the MGO liability. GECL was willing to accept this, but subject to a reasonable revision of prices. The informant's argument regarding GECL not incurring any financial liability for the gas which is flared is flawed, as royalty payable to the government is only one component of the cost involved. There are other production costs incurred which cannot be recovered in case gas is flared up. Further, GECL cannot divert gas which is not consumed by one customer and another customer, as this would depend on the requirement of other customers. In case of stoppage of supply, both GECL and SRMB can terminate the contract. So, Malad, this is Malad CCI's foundation finding, and on that basis, paragraph 95, Malad, at page 125. Based on the above discussion, Commission is of the opinion that no case of contravention of the provisions of Section 4 of the Act is made out against opposite party. Then, Malad, this was challenged before the competition in appeal, Malad, which was dismissed, saying, Malad, that it was not maintainable. Then, Malad, they filed a writ petition before the High Court, which is, Malad, at page 127. This is an order of, Malad, 10th October 2019 of Justice Bakru, Malad, 10th October 2019.
Appeal from CCI went to where?
Malad, to the competition appeal, Malad, it was competition appellate tribunal.
Inclat.
Now, Malad, it's come to the NCLAT. Now the jurisdiction is, Malad, correct. It's, Malad, before the NCLAT. That was abolished, Malad. That body was, Malad. Kindly, Malad, come to page 127, Malad. The judgment starts at 129, paragraph 3. Petitioner is employee of Messrs. SRMB Srijan Limited, company called Companies Act, Rolling Mills and such. Then, Malad, paragraph 7, Malad, it records the filing of the information under section 19(1)(a). Then, Malad, kindly come to straight paragraph 17 on, Malad, the
12.
Sorry, Malad. Page 17, Malad, page 133.
Compat was the appellate tribunal.
Yes, Compat. Malad, it was the competition appellate tribunal. Compat. It was a competition appellate tribunal. Malad, it's recorded in this order also somewhere, Malad, that appeal was held to be not maintainable. I don't know, Malad, unless Compat, Malad, has any other. I don't know whether I missed it or not, Malad.
Nothing. Carry on. Carry on.
I'm sorry, Malad. The copyright, Malad, I'm not. Hopefully, Malad, I'm not infringed, Malad, any copyright. Kindly, Malad, look at paragraph 17. Starts at page 133. And the just before paragraph, at the end of paragraph, page 133, last 4 lines, he submitted.
Yes.
This is their submission, my lord, of the appellant. He submitted, or the writ petitioner here, submitted that CCI had premised its decision on the assumptions that once CBM was produced, it could not be stored. If the same was not off-took, GCL would have no option but to flare up the gas, as there was no provision to stock CBM. He submitted that his assumptions are without any basis. He also referred to the additional affidavit and submitted details as provided therein, indicating GCL's market was expanding and the quantity of gas being flared was being reduced constantly. So same submission, my lord, which is being made here was made there. He submitted that this indicated that after termination of the GSPA, total quantity of gas flared by GCL was less than the contracted quantity of CBM. Then, my lord, 18, according to Mr. Banerjee, the same indicated, not me, my lord, same indicated, same that the quantity contracted to be sold to SRMB was not flared but was sold to some other buyer. He submitted that in the event the gas was flared on account of SRMB not accepting the contracted quantity, GSL would not have to pay either royalty at the rate of 10% of the state government or the production level payment rate of 12.25% Government of India. However, there was no corresponding reduction in the MGO liability. Next, he submitted that GCL had clearly mentioned that it had secured aggregate commitments to purchase up to 412 SCM of CBM as against 88 SCM. It should be MMSCM, or it's million standard cubic meter. He submitted demand for CBM cost was thus much in excess of this quantity produced by SRMA. Now, Mullah will recall, Mullah, this particular line was, Mullah, in respect of March 2013. The CRISIL report, Mullah, will recall, Mullah, I had shown that. Here also, Mullah, they do not mention it. The termination, Mullah, is in 2014. And the wells were expanding. So they go on relying, Mullah, on this 412. And my learned friend has also showed that. But Mullah, I pointed out it's of 2013 and not, Mullah, 2014. Then kindly come to next is, Mullah, paragraph 23. Is on the question with a further inquiry. That was the challenge. Now 39. Now kindly come to paragraph 39, which is at page 146. In the present case, CCI had noticed. Sorry, Mullah, page 146. Paragraph 39.
Yes.
In the present case, CCI had noticed that the parties had exchanged drafts of the GSPA before finalizing the same. More importantly, some of the clauses which the petitioner claimed were unfair and discriminatory had not been objected to by SRMB during contractual negotiations. Clearly, in these circumstances, the decision of CCI to take into account that the GSPA was a negotiated contract cannot be faulted. The petitioner has alleged that clauses 4.2, 4.3, 4.4, 5.1, 5.2 Mullah is the MGO, 6.1, 9.2, 10, 11 sunshines were unfair and discriminatory and thus fell foul of section 4.2 AI of the Act. The DG had found that clauses such and such to be imposing conditions constituting an abuse of dominant position under 4.1 AI of the Act. CCI had, after examining the DG's report in this regard, as well as considering the submission made by SRMB and GCL, rejected the allegations that the said clauses of the GSPA embodied terms and conditions which fell foul of section 4.2 AI of the Act. Before proceeding further, it would be apposite to refer to the relevant clauses of the GSPA, including the ones that were concluded by GSPA to be unfair and discriminatory. Then, Mullah, 2.0 is the period of contract considered, 25 years. Then 4 is delivery. Then, Mullah, at page 150, 5.1, then 5.2, 151. This is, Mullah, the MGO clause. So Delhi High Court also sets out, my lord, all these clauses. Then, my lord, will kindly come to, after setting out all these clauses, at page 161. My lord, 46 at 163 deals with 4.4, then 47. Kindly come to my lord, paragraph 47. 50 is very important. The petitioner's principal grievance, 163. My lord. Petitioner's principal grievance is with regard to clause 5 of the GSPA, in as much as it obliges SRMB to pay for the minimum guaranteed offtake, MGO, in terms of clause 5.1, SRMB and GECL was entitled to terminate the GSPA in the event GSPA failed to supply gas for a period of 3 months. DG reasoned that this enabled GECL to unilaterally stop the supply in order to terminate the GSPA at will. Plain reading of clause 5.1 does not support this view. GECL could reduce the gas supply only due to technical production interruption and other reasons. Plainly, this clause did not enable GECL to withhold supply of gas without good reason. Furthermore, SRMB would be well within its rights to raise dispute if GECL withheld the supply of CBM without sufficient cause. There is nothing unfair in enabling parties to terminate their agreements if the performance of the contract is adversely affected due to certain specified reasons. The expression "other reasons" is required to be interpreted applying the rule of Nossiter Arsoki. In so far as the MGO liability is concerned, the DG had recognized that MGO clauses were standard in gas supply agreements. However, it had sought to distinguish other agreements on the ground that the said agreements were between distributors and purchasers, whereas GECL was a producer. 49, DG had reconciled held that this paragraph 67 I've already shown. Then paragraph 50. It is contended on behalf of the petitioner that the aforesaid reasoning is flawed, since there was no material on record which would lead CCI to believe that GECL could not divert gas to other consumers, and the same would have to be flared. It is also pointed out that GECL's market was expanding, and the amount of gas being flared was reducing progressively. Aforesaid contentions are unpersuasive. Undisputedly, clauses providing for MGO liability are common in gas supply agreements, and it makes little difference that the DG had found them in agreements between distributors of gas and consumers. Rationale for including such clauses is to mitigate risks resulting from non-acceptance of gas supply. This would apply equally, irrespective of whether the supplier is a producer or a distributor. There is also no evidence to suggest that such clauses are not included in agreements between gas producers and distributors. It is important to note that a certain amount of gas was being flared. Obviously, if the same would be supplied to consumers, there would be no reason to flare the same. This may be for various reasons, including mismatch of demand and supply at a given point of time, inability of GECL to supply the same, inefficient management of production distribution, inability to store CBM and other technical reasons. Nonetheless, it is undeniable that MGO liability would mitigate the risk of loss due to non-acceptance of gas. Mr. Sunset also referred to additional affidavit to point out, kindly similar to their own case now, that the total gas which was flared up after GSP had been terminated was less than the contracted quantity. According to him, this implied that the gas earlier being supplied to SRME was being sold to some other buyers and was not flared. According to him, this established that MGO liability clause was unfair. The said contentions are unsubstantial. It is nobody's case that gas could not be supplied to other consumers. It is not SRME's case that if the customers are available requiring gas at the particular point of time, gas available to GSL would not be supplied to them. As noted earlier, MGO liability was only to mitigate the risk in committing to a long-term supply. Thus, the fact that the quantity of gas which was earlier supplied to SRMB was after termination of contract being supplied to other purchasers does not in any manner render clause 5.2 of the GSPA either unfair or discriminatory. And DG found Malad 54 is DG found clause 6. Then Malad kindly come to 61. At page 170. It is relevant to note that GECL and SRMB had entered into the GSP on 11th May 2011 At the material time, no grievance has been raised by SRMB regarding the GSP. DG's report indicates that SRMB commenced negotiation with SR for supply of CBM in 2013. Thereafter, on 22nd April 2014, it requested GECL to waive the MGO liability. The GECL responded on 24th April, accepting the request on a condition the gas price be increased by a sum of rupees 5 per SCM. On 25th April, SRMB entered into an agreement with SR for supply of CBM. Thereafter, on 16 May, SRMB declined GECL's offer to waive the MGO liability subject to increase in price by 5 per SCM. It instead called upon GECL for reduction of the price of CBM by 5 per SCM. This was declined by GECL on 23rd May. However, GECL agreed to reduce the MGO from 80% to 75% of the contracted quantity. SRMB has stopped taking gas supply from GSL on 1st May 2014, and thereafter in June 2014 moved the Calcutta High Court, and the court preferred the parties to arbitration. Thereafter in August 2014, SRMB sought to agitate the matter SRMB sought to agitate the matter before the Ministry of Petroleum and Natural Gas. However, it is noted that the matter was closed by the government after seeking a reply from GSL. Complaint before CCI was filed in September 2014. It plainly appears that the petition had been put up by SRMB in view of the disputes that had arisen between SRMB and GC. So that was the employee. So it is now considered that on this ground, then sees 65, the last 3 line. Bearing the aforesaid in mind, this court was of the view that the present proceeding abuse of the process of law, whereby the petition has been put up by SRMB to pursue the present proceeding. View of the above, present is dismissed with cause, contained 15th page. And this will recall in the award. It is also recorded in 2 places, saying that we are not disputing the findings of both CCI and the Delhi. I mean, law also they can't do it. So the concession is really not something which is contrary to law, but they also in any event they have said that we are not disputing it. So the situation now stands that our submission that CCI records that the DG's finding from the annual report was that 28.48% so far as 2015-16 is concerned. Admitted position they have not disclosed our annual return for 2015-16 so as to contradict that. Up to 2013-14 it is produced, but 2015-16 has not been produced. Second CRISIL and CARE report combined together again shows 2 or 3 things. First, CRISIL shows that I have tremendous reserve in trillion, and I can dig a well and can get gas out. It also records that I have some long-term contracts, and that particular line where they say 428 is the demand and 88 only is the production, that is for up to March 2013. Now that is irrelevant. We can't work on assumption. Either you show it or you can't rely on 2013 figures to say that now you assume this. And termination is only in May 2014. May 2014. And admitted position is in 14 also. They show some flaring up, which is again their submission both before CCI as well as before the Delhi High Court. They only say their contention is, oh, it is less than what was being flared up before, which means I was supplying to others. Of course I was. And that's exactly the logic of all these cases. The example I was giving now, the judgment I relied on of Justice Abjan. Which shows that what is this contractual damages which is to be given. I've lost 1 bargain. I might add my bargains. I would have had 2. If I lose 1, I might add another 2. Doesn't mean that the bargain which I've lost will go away. And this is exactly the logic on which basis the damages have been given. Now, my lord, I just, my lord, now want to come to, my lord, the judgments which we had relied upon. 80 Bridgepal, my lord, is the first judgment, my lord, which, because if the contract had been performed, you would have actually got it, my lord, for 20 years. There's actually which nothing stops, because if the termination is considered to be illegal,
Contract was of 2011.
my lord, 25 years, not 23 years.
It was till 2034.
2034,
yeah,
correct.
but
From 2011,
from 2011.
over 23 years. So instead of that, my lord, the arbitral tribunal had thought fit, in their discretion, to reduce, my lord, that entire claim which I made. Because had they not taken, my lord, for the next 23 years also, they will have to continue to pay. And when I show, my lord, the Supreme Court judgment, my lord, will see exactly, my lord, what has been held in Bihar State, Orissa, where electricity was suspended because they were not paying. And for the balance period also, Supreme Court said, sorry, you have to pay. Of course, my lord, there the period was shorter. My lord, for electricity, it was 5 years contract. Because my argument will be, my lord, whether, my lord, we also have, my lord, the if, and one of the judgments says so, my lord, the Muhammad Salamatullah al show that if, where what happened, my lord, the district judge, my lord, gave a finding of, my lord, saying 15%. The High Court said no, 10%. Supreme Court said that if that was guesswork, this was worse guesswork. Because you had no reason to now deviate from 15 to say, why is it 10? And then they restored, my lord, the original
15.
Because here, and here, my lord, we are dealing with an award. Breach stands admitted. It is a wrongful termination. What follows? Do I get nothing? Do I get nominal damages because you breached? Or is it reasonable to say that we will make an assessment on the question of loss of profit? Instead of giving the whole thing, we will give you 15% of whatever you have claimed. So, my lord, kindly look at, my lord, 80 Bridgepal. My lord, we had my lord, I'm sorry, my lord, we had given, my lord, the one, my lord, which we had used, my lord, before the first court.
No
we had
problem. No
prepared
problem.
a new compilation, my lord, but I find, my lord, the prints are not my lord, made, so we can, my lord, use. এটা সাপ্লিমেন্ট করে দাও, সাপ্লিমেন্ট করে যেগুলো নতুন আছে সাপ্লিমেন্ট করে দাও। My lord, 80 Bridgepal, my lord, will find, my lord, the first case there, page 1. আমাদের compilation. Volume 2 করে একটা দিয়েছো তো। But kindly look at, my lord, paragraph 8. This is, my lord, 1984. Sorry, 4 Supreme Court cases, page 59. Page 5, my lord, paragraph 8. Once it is held that the respondent was guilty of breach of contract, part of which was already performed, and for performing which the appellant, a Pune-based contractor, had transported machine and equipment from Pune to the worksite near Rajkot in Saurashtra, certainly he would be entitled to damages. One of the heads of damages under which the claim is made is loss of expected profits in the work. Claim under this head is canvassed as before. High Court was in the amount of 4,30,314. Then, my lord, kindly come to paragraph 10. Mr. Aneja, learn it, page 6. My lord. Mr. Aneja, learned counsel for the appellant, urged that the appellant was placed at a comparative disadvantage on account of his two appeals arising from two identical contracts inter partes between being heard on two different occasions by two different benches, even though one learned judge was common to both the benches. Mr. Aneja pointed out that an appeal from which the cognate civil appeal number 1998 of 1970 arises, same High Court in terms held that the claim by way of damages for loss of profit on the remaining work at 15% of the price of the work as awarded by the trial court was not unreasonable. High Court had observed in the cognate appeal that the basis adopted by the learned civil judge in computing the loss of profit at 15% in the value of remaining work contract cannot be said to be unreasonable. In fact, the High Court has noticed that this computation was not seriously challenged by the state, yet in the judgment under appeal, the High Court observed that actual loss of profit had to be proved, and a mere percentage as deposed to by the partner of the appellant would not furnish adequate evidence to sustain the claim. In this connection, High Court referred to another judgment of the same High Court in first appeal number 18 and 1965, did not refer to its own earlier judgment rendered by one of the judges composing the bench in first appeal number 384 of 1962, rendered on sunset. When this was pointed out, Mr. Mehta is only responsible that the court cannot look into records of the cognate appeal. We find that response to technical does not merit acceptance. We are not disposed to accept the condition of Mr. Mehta for two reasons. Firstly, that is an identical contract with regard to another portion of the same Rajkot Jamnagar road, and for the same type of work, the High Court accepted the loss of profit at 15% of the price of the balance of work contracted would provide a reasonable measure of damages if the state is guilty of breach of contract. The present appeal is concerned with the same type of work for nearby portion of the same road, which would permit an inference that the work was also entirely identical. Second reason to reject the contention: ordinarily a contractor, while submitting his tender in response to an invitation to tender for works contract, reasonably expects to make profits. What would the measure of profits would depend on facts and circumstances in each case, but that there shall be a reasonable expectation of profit is implicit in a works contract, and its loss had to be compensated by way of damages if the other party of the contract is guilty of breach of contract cannot be gainsaid. In this case, we have the additional reason for rejecting the contention, same type of work, sunset, division by 15. Then, Malad 11, now it is well established that the respondent was guilty of breach of contract, inasmuch as the rescission of contract by the respondent is held to be unjustified, and the plaintiff contractor executed part of the works contract. Contractor would be entitled to damages by way of loss of profits, adopting the measures accepted by the High Court in the facts and circumstances of the case between the same parties. And for the same type of work at 15% of value of the remaining part of the works contract, damages for loss of profit can be measured. So, they use 15%. Then, Mulad, kindly look at next, Mulad, is MSK projects, which is Mulad 2011-10 Supreme Court cases 573. That's Mulad at page 9. Or Mulad that compilation. So 2011-10 Supreme Court cases 573. And kindly Mulad come to Dr. B.S. Chauhan's judgment, paragraph 38 at page 586 of the reports and page 22 of the compilation. In common parlance, reimbursement means and implies restoration of an equivalent for something paid or expended. Similarly, compensation means anything given to make the equivalent. State of Gujarat's answer. However, in Dwarkadas and state of MP, it was held that a claim by a contractor for recovery of amount as damages expected profit out of contract cannot be disallowed on ground that there was no proof that he suffered actual loss to the extent of amount claimed on account of breach of contract. And 39, in 80 Breachpal Singh versus State of Gujarat, while interpreting the provisions of Section 73 of the Contract Act, this court held that damages can be claimed by a contractor where the government is proved to have committed breach by properly rescinding the contract. And for estimating the amount of damages, the court should make a broad evaluation instead of going into the minute details. It was specifically held that wherein the works contract party entrusting the work committed breach of contract, the contractor is entitled to claim the damages for loss of profit, which is expected to earn by undertaking the works contract. Claim of expected profits is legally admissible on proof of the damages, proof of the breach of contract by the erring party. It was observed that. Then paragraph 10 is quoted from 80 Breachpal. Then kindly take the Salamatullah judgment, which is 1977 3 Supreme Court cases 590 and at page 28 of the compilation. 7 3 Supreme Court cases 590. And you can look at paragraph 3. In the grounds of appeal, paragraph 3, Malad, page 29.
Yes.
Again, Malad, this is Krishna's judgment from the phone matter itself, Malad, again. In the grounds of appeal, there is nothing seen to indicate why the 15% awarded by the trial court should not have been granted. There is only a general ground, ground 6 in the memorandum of appeal, which does not make any specific point at all regarding the quantum of damages. It is true that Sri Parameshwar Rao, waiting for the state, has attempted to draw attention to certain facts lying dormant in the record warranting reduction of the quantum of damages, but we are not inclined to investigate the matter de novo when no ground has been raised in the memorandum of appeal to the High Court. However, the High Court, after setting out the facts bearing on the quantification of damages stated without any convincing reasoning, we think that it will be just and reasonable to put this profit at 10% of the contract price, which works out to rupees 1,25,000. We are not able to discern any tangible material on the strength of which the High Court reduced the damages from 15% of the contract price to 10% of the contract price. Then, Mullah, can you see? If the first was a guess, it was at least a better guess than the second one. I really do not like this quotation. We see no justification for the appellant court to interfere with the finding of fact by the trial court, unless some reasons based on some fact is traceable on the record. There being none, we are constrained to set aside the judgment of the High Court in regard to the assessment of damages for breach of contract. We restore the award of 1,87,000 made by the trial court on account of estimated profits. It transpires that when the trial court passed the decree, the amount was recovered by the appellant. The result that there was nothing more to be paid by the state respondent, of course, answer. So it is really, Malad, if the first was a guess, it was at least a better guess than the second one. Then, Malad, next is, Malad, Dwarkadas, which is, Malad, at page 31. This is 99, 3 Supreme Court cases, page 500. Sir? Sorry. 99, Mullah, 3 Supreme Court cases, page 500. And you want to look at paragraph 9 at page 36, Mullah, of the compilation and page 505 of the reports. The claim of the petitioner for payment of rupees 20,000 damage on account of breach of contract committed by the response state was disallowed by the High Court, as the appellant was found to have not placed the material on record to show that he had actually suffered any loss on account of breach of contract. In this regard, appellant court observed it is not this case that for due compliance of the contract he had advanced money to the laborers, or that he had purchased materials, or he incurred any obligation on account of breach of contract by the defendants. He had to suffer loss on the above and other heads. Even in regard to the percentage of profit, he did not place any material on record, but relied upon assessment of the profit by the income tax officer while assessing the income of the contractors from building contract. Such a finding of the appellate court appears to be based on wrong assumptions. The appellant had never claimed rupees 20,000 on account of alleged actual loss suffered by him. He had preferred his claim on the ground that had he carried out the contract, he would have earned profit of 10% on rupees 2 lakhs, which was the value of the contract. This court in E.T. Brijpal Singh and State of Gujarat, while interpreting the provisions of Section 73 of the Contract Act 1872, has held that the damages can be claimed by a contractor where the government is proved to have committed breach by improperly rescinding the contract. And for estimating the amount of damages, court should make a broad evaluation instead of going into minute details. It was specifically held that where in the works contract party entrusting the work committed breach of contract, contractor is entitled to claim the damages for loss of profit, which expected to earn by undertaking the works contract. Claim of unexpected profit legally admissible and proof of the breach of contract by the earning party. It was observed. Then, Malad, the quotation is there, Malad, from A.T. Brijpal. Then, Malad, again, Malad, placitum on marginal note E. Same effect is judgment Muhammad Salamatullah, Government of AP. That is also not noticed.
Yes, Mr. Banerjee,
Yes, my lord.
will you continue?
My lord, I can stop now, my lord.
No, will you
after,
continue after recess?
my lord, up to, my
Up
lord,
to you, up to you. এগুলো নাও।
my lord, I have no difficulty. My lord, I only have one. I don't know whether that will happen or not because the other side, I have a matter fixed at 2 o'clock, which will take, my lord, 5 minutes. If the other side is there, and it will take no time, my lord, if the other side is not there. So, my lord,
Let
that's
us
the
come
only-
10 minutes late.
I'll be. If my lord is, I'm great. I'm great. Oh, no.
That matter was taken up.
Sorry, my lord, the learned judge did not put. It was fixed at 2, but
Uh,
my lord, I'll also, my lord, I think I'll also, my lord, stop at 3 or something, my lord permits me, my lord, so that I also don't, my lord. But I'm very grateful. Actually, today, my lord, I got a lot of
correct.
hearing time, my lord. That's why,
Substantial progress could be made.
yes. I think today and my lord, the next day, my lord, whenever I think I'll be able to finish, my lord, my side of, my lord, the submissions.
Yes,
My lord,
Dwarka.
Dwarkadas I've shown. My lord, the next one, my lord, is
এগুলো দিচ্ছ কেন ভাই? কি ছিল দেখাচ্ছে? ও এইটা।
my lord, in that compilation of judgments.
ও এইটা। Yes.
Crest education. And this, my lord, kindly, this, my lord, otherwise I wouldn't have cited. Only because of, my lord, the learned judge, my lord, I'm just showing that. Because it's a single bench, my lord, of the Delhi High Court.
Ah.
Only because of that. We had used it, my lord, before the first court. I wouldn't have cited before the division bench.
Today I'm going to tell him. Yes.
Seen, my lord, part of the learned judge's education. So, my lord, Fiona Justice Rai, my lord, has been apprised of it. My lord, kindly look at, my lord, first, my lord, paragraph 10. The impugned order was passed, the impugned, this is at page 41. The impugned award was passed ex parte on 18th August 2012. The learned arbitrator found that Team Satyam was carrying on a business competing with that of the respondent from the premise of the petitioner's center, for which it was granted a license under contract with the respondent, and the petitioner's directors were featured in the advertisement Team Satyam. Having come to the conclusion that such conduct on the part of the petitioner's directors petitions constitute a breach of the non-compete clause contained in the contract, learned arbitrator awarded damages to the respondent for the period 4th March 2010 until the date of the award, along with areas for the period of 1st April 2019 to 3rd March 2010. Then, my lord, kindly straightway come to, my lord, paragraph 39. Submissions are recorded. Then, my lord, page 55, compilation, paragraph 37, 2, my lord, the heading is quantification of damages. 38, my lord, I can read also. The learned arbitrator has quantified the damage on basis of the respondent's earnings from the contract during the period 1st April 2019 to 30th March 2010. That is, during the period the contract was operative. In addition, the learned arbitrator awarded a sum of rupees 1,50,000 towards areas of license fee and rupees 2,21,000 towards payment for the study material supplied by the respondent to the petition. However, is rejected the respondent claim for further damage on account of infringement of intellectual property rights, third party side. Mr. Krishnan's argument was that the amount of damage is entirely speculative and unsupported by evidence. I am unable to accept his submission. Future profits can, by their very nature, not to be a matter of strict proof. The amount earned by the respondent during the currency of the contract has been used as the benchmark to estimate damages. Judgment of the Supreme Court in Dwarkadas, relying upon E.T. Brijpal, holds that a broad evaluation is required to estimate expected profits rather than minute details, and disapproved of the decision of an appellate court reversing the findings of the trial court in this regard, even if it was based upon guesswork. The judgment of this court in Kishanlal Kalra, which has been relied upon in the impugned award, specially upholds an award of damages on the basis of past earnings under the contract. Loss of profit is claimed on the basis of 1 week sale figures, for which exhibit PW 2/136 filed. On the basis of such calculation, profit for the unexpired period of lease would have to come to more than rupees 5 lakhs. plaintiff has half or confined his claim to rupees 5 lakhs under this head. There cannot be a direct and concrete evidence of such a loss. Damages on account of loss of profit and the nature of prospective and therefore necessarily contingent. It is now well-established principle of law that the mere fact damages cannot be assessed with certainty does not relieve the wrongdoer of the necessity of paying damages. Chaplin and Hicks and Begin and Permanite. Justice Devlin observed, where precise evidence is obtainable, court naturally expects to have it, but where not, the court must do the best it can. Since it cannot be measured with precision as to what profits the plaintiff would have earned had he continued to run the restaurant for remaining term of the license, and the figure given by the plaintiff for the period he actually did business could be the best indicator. This is what the plaintiff has done, and based on this formula, plaintiff has been able to prove the likely loss of rupees 5 lakhs. Petitioner is accordingly held entitled to the amount of rupees 5 lakhs under this head. Further, the division bench Sikkim court in KMC Brahmaputra side Mr. held that an objection of this nature is not sustainable under Section 34D Act. In the present case, findings of the learned arbitrator are based upon a reasonable indicator, that is, the earnings which actually accrued to the respondent during the time the very same contract was worked, and I find no reason to interfere with the same. Now, my lord, I am only showing this to show here the indicator was past earnings. In our case, indicator is the MGO clause. Instead of giving me the whole thing, and we have also accepted, my lord, quite possible, my lord, we could have come up and say, why have you not given me for all these remaining years which I would have got? Because you held the termination to be unlawful. But the indicator has been taken, my lord, as the MGO clause with a cap of saying that since 15% we have seen in 80 Brijpal and the other ones, 15% has been taken as an indicator of the expectation of profit in a works contract. That has been applied here, and my lord, we have been given 15%. So two things, my lord, though my lord, this is a single bench, my lord, kindly, my lord, take this, my lord, as part of my argument, my lord, as persuasive, my lord, on the question of, I am saying two things. First is the indicator is, my lord, the MGO clause. Second, to say, my lord, if the arbitrators have exercised their discretion on a matter of, my lord, principle or a matter of evidence, unless, my lord, this court finds that completely wrong or a completely impossible view, then, my lord, the division bench, my lord, really should not, my lord, consider, my lord, then, my lord, really, my lord, going into the award. So that is my submission, my lord, relying on, my lord, this. And I've shown, my lord, the other judgments, all of them, 15%. Then Salamatullah says that if that guesswork is the line, my lord, which, my lord, we're looking at, the guess is, if that was a guess, this is even, second guess is even worse than the first guess. So, my lord, this is, my lord, what I'm relying upon to show, my lord, the basis as to why, my lord, the award, my lord, should be sustained. Then, my lord, next is Sangyong. Lord, Sangyong Engineering at page 58. Lord, this is 2019-15 Supreme Court cases 131, page 58 of the compilation. It's a long judgment, and, my lord, it considers everything, my lord, in public policy. Kindly come to, my lord, internal page, compilation page 97 and 170 of the reports. (38), my lord, will kindly look at paragraph 38.
Yes,
Paragraph 38.
paragraph 38.
Secondly, it is also made clear page, my lord, 97. Compilation page 97,
Yes,
my lord,
yes.
and paragraph 38. Secondly, it is also made clear that's right, has got that reappreciation of evidence which is what an appellate court is permitted to do, cannot be permitted on the ground of patent illegality appearing on the face of the award. To elucidate paragraph 42.1 of the associate builders, namely a mere contravention of the substantive law of India by itself, is no longer a ground available to set aside an arbitral award. 42.2 of associate builders, however, would remain for if an arbitrator gives no reason for an award and contravenes section 31(3) of the 1996 Act, that would certainly amount to a patent illegality on the face of the award. Changes made in 20th by the amendment really follows what is in paragraph 42.3 to 45. Associate builders, namely that the construction of the terms of a contract is primarily for an arbitrator to decide, unless the arbitrator construes the contract in a manner that no fair-minded or reasonable person would, ensure that the arbitrator's view is not even a possible view to take. Also, if the arbitrator wanders outside the contract and deals with matters not allotted to him, he commits an error of jurisdiction. This ground of challenge will not fall within the new ground added under section 34(2)(a). Then, what is important to note is the decision 41, my lord, which is perverse as understood in paragraph 31 and 32 associate builders, while no longer being a ground for challenge under public policy of India, would certainly amount to a patent illegality appearing on the face of. There's a finding based on, then kindly see, my lord, a finding based on no evidence at all or an award which ignores vital evidence in arriving at its decision would be perverse and liable to be set aside on the ground of patent illegality. Additionally, a finding based on document taken behind the back of the parties, well, that's not relevant. So here, my lord, we'll have to consider, my lord, whether CRISIL and CARE, which is what the whole emphasis has been.
Vital or not.
Yes. Whether, my lord, it changes, it is so fundamental that it will change the course, or it would have changed the course of the award. And, my lord, I have also shown, my lord, in that in the award, my lord, paragraphs 215, my lord, where part 4 is considered of the argument, there, my lord, CRISIL, CARE, and their relying on the DG carbon, my lord, returns which were filed. So that was commented upon, my lord, in the award. So it's not that, my lord, it has not been noticed, but it has not been considered to be vital. So that's why I say, my lord, my learned friend, my lord, would have to show that this is such a piece of evidence that it would have gone to the root of the matter, and the arbitrator would have said, oh, sorry, we can't give you any damages at all because of CARE, what CARE says or CRISIL says. Otherwise, without that, my lord, it's no point, my lord, and with great respect, my lord, to my, there is no point in saying that, oh, this was not considered or that was not considered. Now, my lord, kindly look at, my lord, next is, my lord, that Bihar State Electricity. I just want to show, my lord, how the Supreme Court has dealt with, my lord, this kind of clauses. Where, my lord, it's been upheld because a breach of that, my lord, what will be the consequences? What, my lord, the arbitrators have dealt with. My lord, at page 146 of, my lord, the compilation, 1990, volume 1, Supreme Court cases 731. Bihar State Electricity Board. This is, my lord, where the arbitrator has considered this, my lord, quoting, my lord, from Shoilowala. First, kindly see, my lord, paragraph 7. At page 149 of the compilation and 734, my lord, of the reports. The question, sorry, my lord. The question to be decided I'm sorry, my lord, may I just show I'm so sorry, my lord, I just want to show paragraph 4. My lord, will find, my lord, what is the sorry, my lord, paragraph 4. High Court took the view that the board itself having effected the disconnection, it was not entitled to any charges for the period after September 1981, and it was not open to the board to contend that under clause 9 of the agreement, it was not open to either party to terminate the agreement of minimum guarantee charges before the expiry of 2 years from the date of the agreement. In that view of the matter, the High Court quashed the bills as well as the certificate proceeding but allowed the charges for the months of July, August, and September 1981 to be adjusted against the security money. So up to my lord disconnection they allowed, High Court quashed the rest. In that context, my lord, we find 7. The question to be decided is whether, despite the fact that the supply line was disconnected on September 28, 1981, the firm was still liable to pay the minimum guarantee charges under the agreement. The answer depends on the agreement itself and the relevant provisions of law. Clause 4 of the agreement says consumer shall pay to the board for supply. Then the clause is set out. Then kindly see from a perusal after that quotation. From a perusal of the above clause, it would be clear that the minimum guarantee charges would be payable by the consumer irrespective of whether energy to that extent has been consumed or not. Indeed, there would be no need for such a provision if the charges were to depend only on the energy actually consumed. Then paragraph 8 clause 5 is set out. Then kindly straight away come to paragraph 17. It is seen at page 153. It is seen that the rule of charging minimum guarantee charges has been in vogue since long. London Electric Supply Corporation versus Predis, the agreement between the appellant company and the consumer to supply electricity, in clause 4 provided that the consumer shall have the option at or before the expiration of 5 years from the date of installation of purchasing installation at a price. Clause 7 said consumer shall, until purchase the aforesaid, pay quarterly to the supply company for the use of the installation 3/4 shillings per board of trade unit for every unit of electricity energy supplied to the said premises, and the minimum payment in any year shall be 1 shilling for each 8 candle power lamp or its equivalent installed. During the period from midsummer to Michaelmas 1900, defendant did not use any electricity supplied by the plaintiff. Question was whether under the agreement, defendant was bound to pay the minimum payment provided for by clause 7, even though in fact he had used none of the plaintiff's electricity during the quarter. The Lord Chief Justice, in giving judgment, said that it was sufficiently clear that the installation was put in on the terms that the customer should have the right to purchase the installation after 5 years, and during that 5 years, customer should be liable to pay minimum rent whether the current was de facto used or not. Minimum rent had no reference to the amount of current used, and it was therefore clear that the mere fact that the defendant had not taken any current or a small current did not affect the case. Justice Channel concurring said that the meaning of the clause was that the minimum rent did not merely cover the actual use, but the right to use the current. Customer had to pay for the right to use the current, although he did not in fact use it. Then 18 is that Tholobala Roy, which I've cited, the judgment of Justice Rupendra Kumar Mitter. Then paragraph paragraphs 23 sorry 24 actually 24. For the foregoing reasons, we have no hesitation in holding that the agreement was reasonable, valid, and it was not determined with the disconnection of supply to the respondent firm by the board on September 20th, but only according to the stipulation clause 9b of the agreement as discussed above. Liability to minimum guarantee charges therefore continued till the termination of the contract. Board was therefore entitled to submit the bills and make the demand on that account and recover the same according to law. Then kindly take the Odisha State Electricity Board matter. That's page 157 and reported in 1993. Supplemental 3 Supreme Court cases 481. Kindly take paragraph 3 at page 157. These were all considered and cited before the learned Arbel tribunal and considered by the tribunal with regard to this clause. (481), sir. (481) Paragraph 3, 481. The respondent is an industry. It entered into an agreement with the appellant for supply of electricity on March 5, 1965. Agreement was valid for a period of 5 years. He started availing of the energy with effect from July 31, 1965. Supply to his industry was disconnected on April 30, 1968 for non-payment of electricity charges. Since the consumer also failed to pay the minimum charges for the period subsequent to the date of disconnection, both filed a suit for the amount due on account of the electricity consumed between April 1, 1968 and April 30, 1968, and for the minimum charges for the period May 1, 1968 to March 5, 1970. It may be remembered that the agreement between the parties was valid up to March 5, 1970. The trial court decreed the suit as paid for along with interest of 6% per annum on the amount decreed from the date of suit till the date of decree, and also future interest at the same rate till full satisfaction. On appeal, the High Court sustained the decree of the trial court only for the period up to the date of disconnection, April 30, 1968, but disallowed the claim for the period subsequent to the date of disconnection. The reasoning of the High Court is that inasmuch as the supply was disconnected and the respondent consumer did not avail of any energy whatsoever during the period subsequent to the disconnection, it is not liable to pay the minimum charges. In this appeal, it is contended by the learned counsel for the appellant that the question arising therein is concluded in favor of the board by the decision of this court in Bihar State Electricity Board, Patna versus Green Rubber Industries. On the perusal of the judgment, we find that that was also a case where the claim inter alia pertained to the period subsequent to the date of disconnection till the expiry of the agreement. In that case too, the minimum charges were claimed by the board even for the period during which supply remained disconnected and no energy whatsoever was availed by the consumer. We also find that clause 4 of the agreement considers the decision, clause 6 and 13 agreement are substantially same. Clause 13 of the agreement, the clause reads as follows. Then, my lord, the clause is set out. Then kindly see paragraph 5. The reason for such a stipulation and its justifiability are duly and fully explained by this court in the aforesaid decision. It is not as necessary for us to reiterate the same. The appeal is accordingly allowed. The judgment of the High Court is set aside, and judgment and decree of the trial court is restored. So, for the balance period also, the court felt that yes, it should be given. Now, my lord, from page 160, my lord, we also relied on, my lord, other decisions of, my lord, different jurisdiction to show, my lord, this is a kind of clause which is, my lord, an acceptable clause with regard to. I'll just, my lord, give the paragraphs and just try and, my lord, read just only those paragraphs and nothing else, because this was all considered, my lord, by the HON'BLE tribunal itself. So, my lord, perhaps it's, my lord, just multiplying, my lord, unnecessarily, my lord, these authorities. Page 160, my lord, this is M&J Polymers Limited. Again, my lord, commercial, Queen's Bench Commercial Court, Justice Burton. What is the paragraph? 639. Lord, in Malad can just, Malad, I'm sorry, Malad, the paragraphs are also, Malad, indicated in the index. Malad just wants to make a note, Malad, of paragraph 6, 39, 40, 46, and 48. It all is
639.
M&J Polymers Limited. একদম ইন্ডেক্স করে করো অনেক ফল I know that. I know that. You come a little late. What happens? Malad, sorry, Malad. So, Malad, kindly just look at Paragraph 6, I think, my lord, may also be a little highlighted. I'm so sorry, my lord. Shouldn't be, but my lord, perhaps it will be at 163. Second question, whether sums due to be paid by the defendant, claimant received period prior to what is now accepted to have been retribution recovered in debt. So that was one of the issue. And my lord, nice paragraph to my lord, paragraph 39, my lord, which is at 176. And it's one of the issue relates to the claimant's claim in respect of the shortfall of deliveries of 1183 BTC2 and 1160 and 1140 until reputed determination of the supply contract. Reputed termination. The claimant claims the price of such shortfall pursuant to the take or pay clause, Article 5.5. Defendants assert claim pursuant to the take or pay clause amounts to a penalty, and that the claimant must be limited to a claim for breach of the defendant's obligation under Article 5.3 in order to specified minimum quantities. Common ground that once the contract was terminated, made in respect of the balance to supply claim is damaged only as it did not seek to keep the contract. It is strange that, at least according to researchers of both counsel, there is no previous authority as to whether a take or pay clause amounts or can amount to a penalty. A take or pay clause is a familiar provision in commercial contracts, and the commercial courts has been dealing with commercial disputes for more than 100 years. Maybe there are such authorities which have not been unearthed, although they are not known to me. They're not known to me either. It may, on the other hand, previously been suggested that take or pay penalty which may count against the argument defendant's case. They're not in maybe a virgin ground. I think there's a point. Then the decision is in paragraph 44 at page 178. Sorry, Malad, 46. May I show, Malad? Just, I'm so sorry, Malad. Just skip over Malad, 44, 45. If I just show 40. On the facts, page 180. On the facts of this case, I'm entirely satisfied that the take or pay clause was commercially justifiable, did not amount to operation, was negotiated and freely entered in between the parties of comparable bargaining power, and did not have the predominant purpose of deterring a breach of contract, nor amounted to a provision in terrorism. Evidence was wholly clear. Negotiations took place between extremely well qualified, able and savvy commercial men against a very significant commercial background, including a background of previous dealings. At the time when they were negotiating, there was on the one hand an extreme scarcity in acrylic acid, a willingness on the part of the claimant to commit supply to the defendant, notwithstanding requirement of their other customers, but in return expecting an absolute commitment to take a minimum quantity of the product to be manufactured with that acid. And on the other hand, a clear recognition of the difficult commercial position in which the defendant found itself, a desperate need to secure supplies of the product, and a desire to keep the contract as short as possible, with the result that they were give and take on both sides, a shorter term that the claimant desired and a longer one than the defendant desired. But so far as defendant was concerned, significant advantage then saw get out clause via the meet or release provision in Article 6. Then Malad 48. There's more of the same. I'm entirely satisfied. Take or pay provision does not offend against the rule against penalties, and the claimant is entitled to recover the price of the shortfall pursuant to Article 5.5. This enables me to be satisfied that I can uphold and enforce a clause which can be described in similar terms of those by Justice Millett, at where the court was asked for the first time to strike down penalty standard law. Now, two things, I want to comment. First, all these factors have been considered, in the CCI and the Delhi High Court, when they challenged this clause as being oppressive or as being unconscionable and anti-competitive, which was rejected. Very similar to what is being held in this judgment. It is already held against them in those proceedings. And my lord, kindly see another very interesting thing. 2013 figures show that, my lord, demand was more, supply was less. They ensured from 2011 to 2013 that they will be supplied in a market where supply is less. Lord, I hope, my lord, so the negotiation which happened, they have ensured, my lord, where supply is scarce, that they will get their minimum guaranteed output. That piece of evidence, if, my lord, at all, it works against them. In a restricted supply market, you have ensured that you will have your minimum guaranteed output. And that is why you ensure that you enter into a long-term contract. You did not know SI is going to come in. You did not know other wells are going to come in. That's why you negotiated and ensured that you got your supply, irrespective of whether, my lord, the supply was there or not. And now you want to turn that against me and say, sorry, you have more demand than supply, so therefore and in fact, my lord, this judgment also notes, my lord, this, if my lord looks at paragraph 46. In the middle, my lord, this is what at page, my lord, 180, paragraph 46, my lord, will find at the time when they were negotiating, my lord, placitum, in between placitum C and D, at the time when they were negotiating, there was on the one hand an extreme scarcity of acrylic acid, willingness on the part of the claimant to commit supply to the defendant, notwithstanding the requirement of the other customers, but in return expecting an absolute commitment to take a minimum quantity of the product to be manufactured with that acid. And then on the other hand, a clear recognition of the difficult commercial position which the defendant found itself, a desperate need to secure supplies of the product, and a desire to keep the contract as short as possible, with the result that there was give and take on both sides, shorter term than the claimant desired, and the longer one that the defendant desired, whatsoever the defendant is concerned. And this is why, my lord, CCI and Delhi High Court laid so much stress on the fact that you negotiated it. You are SRMB, you are no less. I am GCL, I am a supplier. I want long-term commitment. You also want your long-term commitment to ensure that supply comes to you. You enter into a minimum guaranteed output clause, which, my lord, will recall the clause. It said that if I am unable to supply, if he obtains,
differential.
Correct. That is why, my lord, CCI also said it's both ways. If today I fail, I would have been hauled up under the contract to pay him the difference.
So they're equitable bullets. It's quite equitable.
Absolutely. That's why, my lord, I said it's equitable. Today, my lord, if I fail for 30 years, you would not have also spared me up to 2031. Or to 34, sorry, 34. I keep sorry, my lord. So, my lord, this is also, my lord, these are, my lord, quite logical. With great respect, my lord, these are, my lord, quite logical. My lord, the next three judgments, I will just refer to them because, my lord, I don't think, my lord, we went a little, if I may say so, my lord, exhaustive, my lord, research at the time of the arbitration to, my lord, try and, my lord, see, my lord, that this is clauses, my lord, not. Page 185. My lord, this is again, my lord, this is, my lord, a Court of Appeal. 185, this is Port of Tilbury.
80. Thank you.
Well, this is paragraph 28 at page 192. I'll just show this one paragraph. In truth, Torah's whole rationale for its implied term is flawed. There's nothing absurd about a take or pay minimum obligation. Such provisions are common and they are particularly used, whereas here one party has to expend significant sums of money for the purpose of the contract and needs to look to the contract for a secure.
Page.
Sorry, my lord, page 192. I'm so sorry, my lord. 192, my lord, of the compilation. Sir, আপনাকে appellate compilation টা দিয়েছে অ্যাড করে এসগুলো পাবেন ওখানে এই পেজটা ম্যাচ করবে না
তুমি প্যারাগ্রাফটা বলো
28 এটা দিতে গেলে in truth, well, it has that Stora's whole rationale for its implied term is flawed. There is nothing absurd about a take or pay minimum obligations. Such provisions are common and they are particularly used where, as here, one party has to expend significant sums of money for the purpose of the contract and needs to look to the contract for a secure annual income stream which will pay the ongoing financial cost of its investment. Minimum payment obligation does not override the port's service obligation, merely provides together with a no set of provision for a situation where the investor is assured its income stream despite disputes on the basis of pay now, dispute later. So this is just to show this kind of clause is again a commercial accepted clause. Then the next one is item 11. This is Universal Resource Corporation at page 195 of my lord's compilation. After 313, sir.
313.
Well, this is a US federal court decision and 199 at HN5 will find. Purpose will find I perhaps it's all highlighted. Purpose of the take or pay clause is to apportion risk of natural gas. This related to a gas production contract. That's why we use this. The purpose of the take or pay clause is to apportion the risk of natural gas production and sales between the buyer and a seller. Seller bears the risk of production. To compensate seller for that risk, buyer agrees to take or pay for it, if not taken, a minimum quantity of gas. Buyer bears the risk of market demand. The take or pay clause ensures that if the demand for gas goes down, seller will still receive the price for the contract quantity delivered each year. Then HN6. The terms after 5 or 6 terms of the take or pay clause are unambiguous, common to the gas industry, and fully enforceable. Because the clause is unambiguous, panhandle's intentions and the possibility future production may be physically impossible, may violate Oklahoma conservation laws irrelevant. Trial court did not err in refusing to consider extremely evident parties for enforcing the same as clause as written. And then this is then we showed another United States Court of Appeal. Again on the question of this gas supply agreements at page 202 Lord, United States Court of Appeal for the 10th Circuit, September 4, 1991. Here also, my Lord, will find. Lord, at page 204, head note 10. Well, that's an extract of the page is given, but I'm just reading the
From the earlier case. That's an extract from the earlier case, or what?
no.
It's the same.
My Lord, it's a head note 10, my Lord. I'll just check, my Lord. The language sounds, my Lord, very.
If you look at 199,
Yes, my Lord. My Lord is correct. वो कौन सा साल?
head note 5.
Arre, please understand what the question is. What is the question? From the previous judgment which I read. Possible, my Lord, because this is.
No, it's identical.
Yes, it's that. My Lord, we had relied, my Lord, on head note, my Lord, 10 to my Lord 15. My Lord, it is absolutely correct, my Lord. It's at page 215 where, my Lord, the original that quotation comes from. Are we seeing me? Correct, my Lord. That's so. Then, my Lord, page 218, my Lord, of the compilation. This is, my Lord, neighboring, my Lord, jurisdiction. I don't know how much, my Lord, we want to rely on it now. So, we took on, my Lord, everything, my Lord, but everywhere we saw this is the same, my Lord. In gas supply agreement, my Lord, these clauses are there. So, my Lord, I think this particular judge also went to the Supreme Court. No, Aisha Malik. My Lord, here, my Lord, paragraphs 23, 26. I'm not reading it, my Lord. Paragraphs 23, 26, 36 to 38, 46,
26.
36 to 38, 46, 47, and 60. And just, my Lord, since, my Lord, we love, my Lord, this little information, my Lord, Justice Malik actually had gone, my Lord, to the Supreme Court of Pakistan, and I think she was the first.
Somehow I have a hunch she was there in Cambridge when I was there. I knew one Aisha Malik.
Possible. Okay, possible. Possible, Shimapa. Because the 59, she's 59. Exactly. 59.
You photographed her. No, would have changed a lot by now.
But, my Lord, maybe I've done a master's from Harvard. I don't know. But that will be interesting. $59.
No.
No. The timelines will not match. It's
yes, but no. What about other jurisdictions? Nepal, China, Sri Lanka.
I think Bangladesh is the nearest.
Nepal and Sri Lanka may not have enough gas. My lord, that's
Yes.
my lord, coming to my lord, one judgment I want to be. সাকলিটা কোথায় বলো? কিভাবে এভাবে করা যাবে ভাই?
We can take out the rest of it. If we ignore from here, E of the
We have the judgments. What now has happened, my lord, is that the entire bunch has again been repeated with my lord, the new judgments which we wanted to show.
Why don't you show it on the next day?
Very well. My lord. Just take this out and put it.
Segregate them, have them separated.
Yes, separate, my lord. We'll just put it as my lord, volume 2 or something, because my lord already has that. Perhaps my lord has already marked it, so I don't want to, my lord, unnecessarily.
Correct.
My lord, anyway, my lord, 3, my lord, I think I'll stop.
Lekho. When shall we keep it? Friday or next week, Monday? Oh, you are not there on Friday.
My lord, Friday in the morning, my lord, I have some, my lord.
Mr. Banerjee, learned senior counsel representing the respondent, resumes his argument but does not conclude. Paragraph as requested, list this matter once again on Monday date thou, at the same position.
My lord, most probably, my lord, that other matter will be there.
Will be
Would
there
have my lord, after that, my lord,
this one.
The Lordship is fixing it at 3 o'clock.
no, Monday, Shokal.
Monday in the morning.
Monday, we'll first take up Vodafone, just like we did today. For some time, Vodafone.
Very well.
So-
Let Vodafone appear above this matter.
Yes.
Otherwise, what will happen is this: I shall be here at
No,
10:30 and I shall bring
Kaushik.
down the neck of
Yeah,
the
আজকে একদম ভুলটা যেন না হয়, দেখো বেশি, হ্যাঁ। Yes.
12:30, sir.
But you take it from us wherever, even if there is an error in printing.
Vodafone will be taken up first,
Yes.
which I didn't know.
Yes, yes. It's always
Well,
mobile gets precedence over gas.
Very good. Well, তোমার কি শেষ হবে এর আগে পরে?
Monday শেষ করে দেওয়ার চেষ্টা করবো, sir.
চেষ্টা করব। Because my lord, I will request your lordship,
If
my
I
lord,
get
to
from 12,
give the
perhaps I'll
reply
finish.
after the 18th.
The 8th. To the
My learned junior is going
The
to
19th.
No problem.
Friday হবে তুমি।
We can give you after vacation also, no problem.
no,
No, that will too late. All this, my lord, good work or bad work we have done, my lord, will, my lord.
No, we have made extensive notes. Point is not very.
No, my lord, it is.
Yes.
It's really a question, my lord, whether my lord accepts, my lord, our, my lord, contention on the question of, my lord, damages, my lord, as awarded, my lord, by the arbitrator.
Again, what really we have to look into, whether the section 34 judge
Correct.
operated within the parameters of section 34.
Absolutely.
Because that is what is under challenge before us, not the award.
that is the point.
That's the, my lord, I'll show, my lord, some few judgments on that. What fell from, my lord, is, my lord, what appears, my lord, to be, my lord, now, my lord, the honorable
But I have gone
Court's view.
entirely on the question of perversity.
Yes, yes. We have noted that. We have noted that. And particularly not even considering,
Yes,
totally
that's the
ignoring
point.
vital evidence.
And my lord, not considering the vital evidence and my lord, taking into account an evidence which is not evidence.
CCI.
28.1.
And the entire award is based upon that.
Monday. 3 p.m. to Dako. There's a fixed matter, which will, I think it will be unfixed. Nobody will be.
Grateful.
In 25, anybody is there?
এটার সঙ্গে ওই
Milord, with regard to the appellate side matter, Milord, Mr. Banerjee is not appearing today. Milord, I am,
Not
Milord,
today.
here for the good faith matter, which, Milord, the original side one.
I appear on the appellant in the original side matter.
No. Not today. If all counsel are not here, we won't take it up.
Or is it, Milord, pleasure to fix any time?
Today it's our pleasure to unfix it and then we'll see.
Very আমার সাথে আমি বলে দিতে পারি, শুনবেন না?
একবার ডেকে দাও বাকিগুলো, এ তো হচ্ছে না।
Item number 5, item number 6, item number 10. Let's stand, I'm there, my lord. This is my appeal, my lord. The other side is there, my lord. I was addressing your lordship.
আজকে না করে পরের দিন করো না।
সেই ব্যবসা বন্ধ হয়ে গেল। তো সাবমিট করছি শেষ
তুমি কোন দিকে?
আমি তো আমার
ও তোমার সাইড। Well, I was making a request for it because and I'll also have to leave because
No, we also have a request from the bar not to take up matters and at least not to pass adverse orders if all the parties are
we
not.
have already, I think,
this is an appeal
extended.
to take some time, my lord. I have to, my lord, start. It's not going to get over. But otherwise, my lord, we'll not get, because it's a cigarette business, my lord. My business is completely stopped.
Consider Mr. Banerjee is making it, it's up to you, up between the two of you.
But my request
Look,
would be
there
if the
is
matter is
Mr.
not
Puji, there is
taken up.
Mr. Bachavat, my lord, they have a lot of
queuing
people.
নেই দেখছো তো, and আমার
My lord, they have to just take notes. Otherwise, my lord, my turn will not come in this matter.
Why
No,
will
it's
it not
what-
come, Mr. Chaudhary?
completely at the top.
Because, my lord,
Your matter, Praveen Kumar is immediately after.
Yeah.
no, my lord, but that is going to also take time.
That too, but can't be helped.
I'm making a request for if it could be taken up.
So long as he agrees. Let it not be understood that we are reluctant.
No,
We
no,
are
no.
not.
That has already taken up. তোমরা কি থাকবে এখানে? থাকো, I have to. Actually, I forgot, I had an arbitration. I completely, in the other matters, argument, I forgot, that I had an arbitration, from.
But I am not concluding today, so there is no question of passing any order.
The only thing, Mr. Roy Chaudhary, unless your other side's counsel are present,
But they are there, my lord.
it may be, Mr. Banerjee may have to go away. I don't understand. So it may be difficult for them to respond to your argument. That is all. That's the way I feel. Then if you want to proceed, we are here. We are here.
আরে তিনটে অবধি হয়েছে না?
তোমার আমায় তো করবে।
তুমি তো করেছো, ভোডাফোন করেছো সকাল থেকে। ছেড়ে দাও, জজ সাহেব এখন।
I have a problem is, my lord, I wouldn't have insisted, my lord. I have a very difficult client, my lord, who's in Punjab.
তোমার সবই ক্লায়েন্ট ডিফিকাল্ট।
No, my lord, it's not like that, my lord. My lord, Vodafone, my lord,
IPR
you
is
should not make
difficult.
any submission with regard to Vodafone. It was an interim arrangement, my lord, which was continuing. Let him, my lord, not make submissions on Vodafone, my lord.
সময়ের সঙ্গে পাচ্ছি না। up to my learned friend, and up to the court. তোমরা থেকে
In that case, my lord, I'll come back on Friday with this, my lord. My lord, at least Friday, my lord, I expect, my lord, at least they'll not.
Yes.
My lord, because, my lord, I'll tell your lordship.
When have we kept Vodafone?
My lord, on Monday.
Then Friday.
both Vodafone and
Only
GCL.
thing, my lord, I'm saying, my lord, because there are, my lord, lot many senior counsels appearing on the other side. It is not possible, my lord, on one day for everybody's availability. That's the only difficulty.
আরে availability হচ্ছে না আজকে।
Not today. Let it run in the list where it is.
Great. Item 12, 13.
13, my lord, 13 and 14, both the applications, my lord, appeals, my lord, what I'm opposing.
Lordship, I am appearing.
Lordship, I am appearing for.
13 and
Lordship, I am
13,
appearing
your lordship.
for.
These are connected appeals.
On the
Your
last
lordship, I
item
was
14.
to file an application producing additional documents, your lordship, under Order 41, Rule 27, your lordship.
they have already.
However, your lordship, because my advocate on record was unaware.
But I would be,
Your
my lord,
lordship,
beseeching your
we
lordship to,
weren't
my lord, right, my lord, close their rights to, my
able
lord,
to do the
file.
same, your lordship.
Madam, it is very, very difficult for us to hear learned advocates virtually. Let us make that clear. Not today.
15.
Your lordship, absolutely, I take note of that.
But only one thing I would indicate, my lord, before parting, my lord, that is, my lord, they have, it's their appeal. Of course, their appeal. They have already filed an application under
Order 41, Rule 27. Yes.
To which they will not want to now file a supplementary affidavit. And this has been going on for 3 weeks, my lord. Lordship,
And we had sought leave, your lordship, but
They have
enjoying a
deposited
stay. They have
the
my
deposited-
advocate on record was bedridden. She was bedridden, your lordship.
But kindly, my lord, takes note of that, that it's, they are not proceeding with the appeal in any which ways.
Today, for other reasons also, Mr. Shawkat,
Yes,
do
of
not
course, I am
interest.
today, of course, my lord.
This will be listed again on Friday.
Very good. Very good. I agree.
Huh.
No, 16 and 17. 18.
Lordship, I appear on behalf of the respondent.
Carefully, appellant, my lord, I'm led by Mr. Jayanto Mitra, my lord. So I'm praying if it could be kept on Monday, my lord, after the SRMB matter. Grateful, my lord.
So 19. 20. 21. 22. 23. 24. Non-commercial. New application item 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23.
My lord, 23 and 24, I am for the plaintiff respondent, my lord. My lord, matter is very short, my lord. All the defendants, my lord, all the respondents are my lord, senior citizen. Any day they will die. But they have already my lord, handed over the possession to the port trust, my lord, only for mean profit are remaining. My lord, they have deposited that residential property, the deed of the residential property. So my lord, court has granted.
Mr. Mondal, how can
Any
we
day, my
fix
lord,
it?
before vacation, my lord. Otherwise, my lord,
How can we fix it? Your other side is not here. Their convenience has to be ascertained.
yes, my lord,
And
yes,
in a
that-
way, this will be an adverse order
yes, no,
fixing
no,
it.
no. That
So
is
it can't be done today. You realize? You have made a request.
for vacation. I need it, my lord.
Sure.
25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38. Thirty-nine, 40.
40, my lord. This is my, I am the respondent number 2. My lord, the appeal is pending. There's an interim order that my learned friends are enjoying. I know today not much can be done. Only thing is if it can be upgraded, because Mr. Bachawat and Mr. Rudraman Bhattacharya were appearing for the appellants and they were on the verge of completing.
Let us upgrade all matters.
Only this matter.
All
I'm not
matters
asking for
upgraded
it.
to the relative position that.
My lord, everything gets upgraded, this stays
Next.
here. That's all.
41.
It's the number one, especially assigned matters. And you
Yes.
see, by rotation,
Yes.
different categories, the headings,
Yes.
they go up one day. So take your chance when specially assigned goes up in the list.
I
Look,
believe,
face it also happens
I
that the
believe Mr. Shurojit Nath Mitra appearing for the other set of defendants also mentioned it on another day when a similar situation was present.
we don't remember. I have very bad memory. Call on the list.
42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63,
একটা রাজপথ
64, 65, 66, 67, 68, 69, 70, 70.
71, my lord, will kindly. I am aware of the fate that's been suffered by the others who've been trying to mention. My lord, it's actually a very short appeal. A defect in a cost title has led to dismissal of my suit in total. Defect as to cost title only, it's a very short matter, my lord.
You have to inform your other side.
Yes, my lord. Mr. Banerjee is
Appeal from orders A. First 5 items.
deeply, extremely.
Which Mr. Banerjee?
Well, Mr. Dhruvo Ghosh is leading him. Mr. Rohit Banerjee is my other side. I've also informed him. I'll inform him right now as well. He's in court premises. Deeply operational.
72, 73, 74, 75, 76, 77, 78, 79, 80.
80, I appear for the appellant. That matter where order 711 application was allowed. Holding that it's a commercial dispute as well as order 2 rule 2 D was not taken. Lordship,
Srirampur Court. No.
Yes, Srirampur Court.
Srirampur Court.
Bengal Sriram, this is with regard to Hindustan Motors.
In Motors. Mr. Ratnanku Banerjee is not.
Yes,
he was there.
He's leading in this matter.
Uri bolto. Hearing to কোনো দিন তার কাছে করতে পারি তবে কি এটা অ্যাপিল ফ্রম অর্ডার্সে ঢুকিয়ে দেবো শুনেছিলাম আমার মনে আছে তোর তুই did this bench hear it or
Yes,
this bench?
What happened was it was partly heard by your lordship. Thereafter there was a change, and thereafter we argued the entire thing before another bench, and thereafter your lordship heard it in part again on some other day.
This bench.
This bench, yes.
We put it under the heading appeal from orders.
Very good.
No, উপরের দিকে দিয়ে দাও appeal from orders এর উপরের দিকে দিয়ে দাও but inform your other side otherwise they'll be taken by surprise.
Oh.
Inform your other side they'll be taken by surprise otherwise.
True. I'll do that, I'll do that.
Who is on your other side?
Mr. Tridip Bose from Khaitan and Company was arguing himself. Mr. Tridip Bose. So I'll inform, I'll ask my advocate record to inform. I'm great.
Item number 4. My learned friend is on the other side. This is my appeal.
Commercial?
No, non-commercial.
Original side?
Original side. It's a new application. Order 7 Rule 11, my lord. My Order 7 Rule 11 has been dismissed. I have preferred an appeal, my lord. I will not be available till 17th. Kindly, my lord, I have taken the consent, my lord. Keep it on Friday 19th, my lord.
Very good.
Okay.
Hey, 19. Monday.
My learned friend says 22nd Monday.
Subject to lordship.
22nd November.
No, September.
September.
My lord, item 71, Mr. Banerjee, I have informed.
Which one?
Item 71, which my lord just upgraded. Item 71, appeal from order, defect in cost title. I have informed Mr. Banerjee.
Yes.
Daku? Oh, no, appellate side, sorry. আচ্ছা তুমি কি ভাবছো কেউ আসবে দেখো তো আগে ডাকো কি আচ্ছা ঠিক আছে
commercial item number 1
কি কারেকশন করতে হবে এখানেই বোধহয় ভুল আছে লিস্টে। ইস্টেন লিখেছে। হ্যাঁ, না আসুক, আজকে নট টুডে, সবই নট টুডে।
Three, 4, 5.
4 and 5, my lord. 5, my lord. I'm opposing. Item numbers
এটা
4
কি
and
কমার্শিয়াল?
yes, ma'am. Yes.
Yes,
If it can be taken up some other day, I'm being.
yes, yes. Not today, only not today.
Only.
My lord, just one thing, I'm appearing for respondent number 2 in the matter. No copy has been served upon us. If a
They were
copy
not
can be
on caveat, my lord. They were not on caveat. I'm challenging an ex parte ad interim order. They were not on caveat. They are one of the defendants.
You have suffered the order.
Yes. They have not.
Now that they are appearing, why don't
Yes,
you
yes,
get them?
definitely. They could have easily. They know my advocate on record. They could have made a formal request. It could have been done.
I would not.
Instead of. Yes, definitely, my lord. Good.
6,
একটা
7,
email করে দাও
8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. It's a non-commercial. Item number 1, 2, 3, 4, 5, 4, 5, 6.
আর নেই, হ্যাঁ, অন্য লিস্ট থেকে এটা